And this is the second part of the inaugural corporate law workshop that we had done last semester. So they've taken you through the M&A deal cycle, and this time we do a deep dive into investment agreements or shareholders agreements. So that's the idea for today's workshop, and I'll leave it to Nimisha to begin the workshop.
Good morning, everyone, and thank you for making it on a Saturday and a non-working Saturday. So I think we started off by asking you guys how many of you attended the previous session, and I think I see a lot of familiar faces. So in the last session, what we covered was, acquisition agreements and generally like a purchase agreement / a subscription agreement. Now, that's a first step to, so to say, when a shareholder is sort of entering the company, either through, through a secondary purchase or, subscribing to new shares of a company. So that's the first leg. And once you're in the company, then you're basically technically a shareholder on the cap table of the company. And now that second phase starts, which is how will the company being run, what are the inter se shareholder rights and obligations, and that's where the next agreement, or let's say the next piece of transaction document in a deal cycle comes through, which is your shareholders agreement. Now we've loosely sort of used this term shareholders agreement, but it's also like an investment agreement, a joint venture agreement, basically anything that will actually govern the rights of the shareholders inter se as well as rights of the shareholders qua the company. So it's not, whatever term you may call it, but because it governs rights and obligations, we typically will call it a shareholders agreement. And as compared to a purchase or an acquisition agreement, this document is actually more important because this has a longer life cycle, so to say. Because if, for instance, an investor is going to be in the company for, let's say, 3 years, 5 years, 10 years, this is going to be the piece of document that is actually going to govern you for that amount of time. And at the same time, this is where your value protection really lies. Because in a purchase agreement, you would have taken warranties, you would have got certain covenants, which sort of ended on the closing date where you actually came into the company. But going forward, how that will, how the company will really run is where you will, you'll find all your rights and obligations packaged in this document, right? So very quickly, what we've tried to do is we've tried to divide this presentation into 3 buckets. The first one is really on management and governance. Now, management and governance is your day-to-day operations, how your board meetings, shareholder meetings will really run through, how many directors can you appoint, and essentially administrative matters, if I may put it like that. The second bucket, what we've tried to put is the share transfer restrictions and exit mechanism. Now, we may say that this is probably the meat of the agreement, because this is where you will look for share transferability. You will see, okay, what is your investment horizon, when do you want to exit, what restrictions you want to put on the promoters and the other shareholders. Then the third bucket is, I won't say like a mix of a number of things. You would see there is something as further capitalization, your preemption rights. Again, if there are more investors coming in, there are future rounds of investments. How do you protect your investment? So basically your anti-dilution rights. We'll obviously delve into all of this as we move along. And certain other things in terms of what are my consequences in case a shareholder or a company defaults, right? Like we discussed, in a purchase agreement, indemnity is your go-to bucket. Now here you're already in the company, you've invested a fair bit of time. So your consequences that you seek out of a default scenario are very different then. And other things like a non-compete, how will, if it's a multi-party shareholder agreement, or where there are, n number of shareholders, do they work as a block, how do they exercise their voting rights? So all of that we cover in the third bucket. Okay. The other thing I want to just point out before we kind of go into the detailed presentation is we've not really made a distinction between a strategic and a financial investor, but we will talk about certain differences in the mindset of a strategic versus a financial investor as we move along. So a strategic investor is somebody who will be in the company for a long time, would want more of governance rights, would want to, be actively involved in certain key decision making, will sort of have a vision for the company and would kind of do things to get that vision into motion. A financial investor is primarily to make the money, but obviously to make the money you need protections and you need to safeguard your interests against, like we said, the other promoters who are running the company, and so you obviously want more, you do want visibility. So there is sort of a difference in approach when it's a financial investor or a strategic investor, and we'll try and talk about it, when we're discussing different concepts. So we'll start with a poll, and if you can all just download Mentimeter on your phones with this passcode. We also have the QR code, so I'll just go on that. Okay, so just to start and really set the motion, and we had a very good response last time, so we are expecting really good answers now. A very normal scenario, there's a company where the promoter group is at majority holding a 55% shareholding. You are the incoming investor and you're taking a 30% stake. To add just another limb to it, you are a strategic investor, so you are interested in actually how the operations of the company will be run. And then there is a third category of shareholders, which will be minority shareholders. There may be some ESOP holders, etc. So what can you think of as key rights or like key restrictions you would want in a shareholders agreement, or any key things that come to your mind as like the first thing that you will look for? Okay, voting rights, anti-dilution, affirmative voting rights. Seems like you guys are already read about it. Information rights, okay. Board seat, a nominee director, okay. Okay. Board member, matters. Reporting covenant, veto, okay. Drag tag. Okay, I see a lot of board rights and then seat on the board. Okay. I think this will be an interesting session. Okay. Okay, so I'll just go back. Okay, I think we got actually a lot of interesting answers from you guys. And again, like we did touch upon it briefly, what the structure of an agreement looks like. Like we said, we've tried to divide it into three main parts, which is management governance, your transfer restrictions, exit rights, and then things like an event of default and consequences of it, a non-compete, non-solicit, other things like generally, your shareholder protection rights. So you'll see a lot of in a shareholders agreement with, let's say, a non-resident investor, they're very strict on anti-bribery and anti-money laundering. So you'll see very, I would say, detailed covenants around that. So that's really the third limb. Okay, now before we go into the document really, let's talk a bit about the famous topic of, do you need to incorporate your provisions of a shareholders agreement into the articles of association of the company? Now, I think that's something we actually do study in college, at least we did, is the shareholders agreement is like any other private contract, which is between the shareholders, and at a lot of times, obviously, a company is made a party to it, but that's typically purely a private contractual arrangement. An articles of association is the bylaws of the company, is the charter document of the company, which sets out the relationship, the rights, obligations of the shareholders inter se, as well as the shareholders in the company. Now that's one document which the company will blindly follow, let's say. And that's something which is, like we all know, is required to be filed with the Ministry of Corporate Affairs, is something that, the first thing you would probably do when you're looking up at a company, what does its governance looks like, what are the rights, etc., transfer restrictions, and probably any other kind of, let's say, peculiar provisions that you come across. So you'll definitely go back to the articles. Now, I think the landmark judgment in this case was the V.B. Rangarajan decision. Now, that was fairly aggressive, right? It said that if you do not incorporate the provisions of a private shareholders contract into the articles, it is not binding on the company. Now, let's divide this also, and there have been various precedents. So we've seen the Bajaj Auto case, we've seen the Madhusudan case, we've also seen the Sham Madan Mohan Ruya case, which obviously was like where the judiciary actually took sort of a contrary view. Now we can divide a shareholders agreement into two parts. One is the transfer restrictions that we've been talking about, and the other is, your governance and other covenant sort of matters. You will see a lot of case laws and precedents actually just end up discussing on the transfer restrictions, and probably that's one area where kind of the dispute really lies, and which is why those matters really go to the court. But there are softer aspects like, quorum rights, affirmative voting matters, etc. And like I said, while this document, we may say that the transfer restrictions are more important, but so is the day-to-day functioning of the company. And God forbid we are in a dispute scenario, you will realize that the smaller aspects actually, that who has the right to appoint, let's say, a chairman, who has the quorum rights, do you have a veto matter on that particular subject matter, actually do play a very large role in a dispute sort of scenario. So I think the pre-Companies Act 2013, let's say safe to say everybody used to take the view that if you want the shareholders agreement to be binding on the company, you definitely need to include the provisions in the articles of association. Now there were a few concerns on that a shareholders document has commercial positions, I've agreed on a value, why am I going to put that into the public domain, and why do I need to put everything that I've agreed under a private document in the articles. Now that's where the drafting hat really comes in, where we kind of do not disclose commercials or any sort of sensitive matters, and usually you'll see those sort of matters are qua the shareholders and not really qua the company. So as long as your important matters are qua the shareholders and it's in a private document, we are protected and enforceability is not at risk. Anywhere where you need an action or enforceability against the company, that should definitely come into the articles. Again, like I said, that's where clever drafting comes in. So you'll probably cross-refer to a mutually agreed document. You will try and use generic language to say, okay, as the shareholders may agree, rather than giving out everything on a platter in the articles, which is generally available in the public domain. Okay. Now, what happens with the 2013 Act? So we all know that obviously the key distinction between companies is there's a set of, like, there's a private company, there's a public unlisted company, and there's obviously a listed company. Private company, free transferability of shares, and in a public unlisted / listed, there is basically no free transferability. Now, Section 58(2) of the Companies Act included a proviso, which was a very welcome change, so to say. But if we see what the proviso reads, it said that any contract or arrangement between two or more persons in respect of transfer of securities shall be enforceable as a contract. So this sort of gives, let's say, a green stamp to a private document and says that, okay, if shareholders have agreed to share transfer restrictions under a private contract, it will be enforceable. But there are 2-3 challenges here, right? One is it says two or more persons. Now, does that mean that is it shareholders only, or does the company still need to be a party to the shareholders agreement? Secondly, as we can see, it restricts itself to transfer of securities. So, like we said, what about the other obligations? What about if I have in a contract agreed that I will have special quorum rights, I will have veto matters? Does that still need to go into the articles or not? So, while there is some flexibility built in terms of share transfer restrictions, we still go back to the board where we say, okay, anything you want to bind the company with, so anything which is related to the functioning operations of the company, you should still include it in the Articles of Association. And more so to say that I think, like I said, there are ways and means to address concerns in terms of not giving out the entire details, but that's really drafting. But that's where the law really stands. Okay, now we delve a little bit more on the board governance, shareholder meetings. So this is actually that one section where your Companies Act comes very handy, because this is actually a major chunk of your Companies Act, which says how the board meetings will be held, how your accounts will be approved, how the shareholders meetings will be held, what are the quorum requirements, notice requirements, how will the chairman be appointed, can you hold an audio-visual meeting, etc., etc. Now here, this may be one chunk of the document that you've done 2 or 3 SHAs, you'll just probably flip over. But like I said, this is actually very important, because once and this is more so important, let's say, for a strategic investor, right? Can a promoter-driven company go ahead and do meetings without the investor's presence? Can you go ahead and approve any and all matters under the sun? Can you, approve a matter in a meeting which was not mentioned in the notice that was served to the directors or to the shareholders, so to say? So again, all of these things is something that you will build in. In a private company scenario, there are a lot more flexibilities, because there are exemptions available to private companies even from a notice or a quorum sort of requirement. But let's say the fundamental rule still remains that you will have to check compliance with the Companies Act. So each time you're doing this section of the document, you will have to pick up your Companies Act, you will have to see what the law prescribes and are there exemptions available, etc. Now often, let's say for a board meeting, a 7-day notice period is sort of prescribed. Now, what you can do is you can provide for more restrictive covenants. So you can say, okay, we need a minimum 14-day period, along with an agenda and, let's say, explanatory notes, etc. We also need a presentation to come to the board, etc. So you will need to kind of work alongside the Companies Act and prescribe what all conditions or what all ways do you want to manage and run the company. Okay, now moving on to director appointments, what are the kinds of directors, how should your board composition really look like? To start with, we can divide the directorship into 2 forms. One is really executive whole-time directors, and the other is a non-executive director. The Companies Act really does not make any distinction, like you will not see the words non-executive or executive director, but you will definitely see something as a whole-time director. But as the name suggests, executive whole-time is somebody who is actually involved in day-to-day functioning of the company, is more involved, is somebody who's expected to run, manage, operate the company really, and actively involved in decision making. Non-executive director, not less important, but is somebody who is not actively involved in day-to-day ordinary course matters. Then moving on, a director and an observer, like the difference between a director and observer. So primary difference is a director is somebody who has a seat on the board with voting rights. An observer is somebody who's entitled to notices of meetings and to attend the meetings. So now let's put it in a strategic or a financial investor scenario. A strategic investor, like I think we saw a lot of those answers also, will want a board seat. And a financial investor may actually be happy with an observer seat. And again, why an observer seat and why do you really need it? Why doesn't, everybody want to be on the board? That brings to the next concept of who is an officer in default. So obviously there are no free lunches, right? So with obviously responsibility comes risk. Now if you have a board seat and you have certain obligations, and now with the fiduciary duties of directors being codified under the Companies Act, you have even more accountability. And these, if you see these fiduciary duties, while they're very broadly worded, you would see that they focus on some 2-3 key aspects. One is that they're not supposed to just have a one-sided agenda. They need to work towards all the stakeholders of the company. So they need to keep in mind the interests of the company in general, of the shareholders, of the employees. They need to act in good faith, work towards promoting the objects of the company, and ensure there's no conflict of interest, right? So one is that added responsibility. Secondly is there are obviously risks against the director in case there is any default. And default, mind you, not just under the Companies Act, default under the various statutory provisions. If you pick up any statute, I think majority of them you'll see have a section towards the end which will talk about offences by company. And you will notice that that actually sort of tries to fix responsibility on the person who is managing the affairs, who's probably sitting at the board and is part of the decision-making process. And generally, an officer in default, how is defined under the Companies Act, is a whole-time director or a KMP, which will be your managing director or a CEO, or somebody who is designated specifically by the board. And in the absence of that, all directors are kind of at equal risk, right? And I think that's where, like I said, that decision of whether you will be an executive director or a non-executive director versus having just an observer right becomes very important. Now, just the finer aspects of board composition. So, minimum number of directors, 2 for private companies, 3 for public companies, maximum directors 15, but you can still increase it with a special resolution. Then there are obviously other requirements of having a woman director, a resident director, or an independent director. Resident director, every company is required to appoint, private, public unlisted, listed. And typically you will see that the obligation of appointing a resident director would lie with the promoter group. And you would probably want somebody who's already continuing, already been on the board to continue and to serve the resident director requirement. Women directors and independent directors. Now this is important because you can't, like I said, this document is there for a longer duration, right? It's not just for a 2-year horizon. This document could actually govern the company for 10 years. So it's possible you're a public unlisted company where you're not meeting these criteria. So on day one, you don't need to appoint a woman director or an independent director. But you obviously have bigger plans for the company, right? Your revenue is going to rise, you may want to list it, etc., etc. Now you are entering into a document at this stage where probably you have like a better bargaining position. And so why not talk about those rights now? Like, why have a myopic view, right? So you'll see that even for companies where this is not really an immediate requirement, we do try and legislate for it. So you will talk about the fact that, okay, in future, if the board needs to comprise of a woman director or an independent director, you would need to increase the board size. Who's going to appoint them? Who's going to have like a nomination right? Will it be a joint nomination? So these are aspects, like I said, you may not need immediately, but something that may come up in the future. Now, board composition, while we've discussed, okay, we need a board seat, do we need an observer right, executive, non-executive, etc. How does typically a board composition look like? Like, does it mean that it's actually commensurate to my shareholding percentage? Yes and no, both. You would typically see, let's say in a 60-40 sort of shareholding ratio, you'll see that the board is also sort of 4:2 or maybe a 3:1. And in a 50-50, you'll see equal representation on the board. So it is to a large extent commensurate to the shareholding. But again, there is no really fixed formula. So like I said, there are a lot of other considerations at play in terms of whether you actually want 1 seat, you want 2 seats, and also the kind of matters you want to block. So we'll cover that in just like probably a few minutes. Is the key things which we saw when you guys were answering was also the affirmative matters or the veto matters. So if I have got a decent number of veto matters, I'm okay with having just like 1 seat where I have visibility on the actions, but I don't need to really exercise control, let's say, of the board, because for every important matter, they're actually going to end up coming to me. Then I think I won't take a lot of time, but quickly touch upon what are the various other things that we see typically in the governance section of an SHA. You will see when and how the meetings have to be held, what is the notice period, what are the kind of agenda details that need to be circulated to the directors, what is the quorum requirement. Now coming on quorum, again, this is important, right? Because just having a board or a seat on the board is not enough. If the promoters, let's say we've got 3 promoter, 1 investor board seat, and going by 4, let's say you just need 3 directors for a valid quorum under the Companies Act, from a Companies Act perspective. So that means the promoter can just get his 3 guys, go ahead, do the meeting, approve matters, and here it's done. Now, we're there for a reason, right? So you would want that at each meeting, your presence is sort of mandatory to constitute valid quorum. This is like where I said your interplay between the Companies Act and private discussions of rights and obligations qua shareholders comes in. Because the Companies Act just prescribes the minimum number of people, but here you're going an extra mile and saying, okay, the presence of investor is necessary to constitute valid quorum. Now, okay, fine, often you will hear the promoters will say, okay, if there is a non-resident director, why do you need to be present? This is going to hamper my day-to-day functioning. And if every time I need to give you, let's say, a 10-day notice, then you may not be available, you may be traveling, which obviously now has become much more easier with, participation through audiovisual means. That gives a lot of flexibility to the directors and, generally the company to still go ahead, convene meetings with, like, not insisting for physical presence of the directors. Now here, when I said the fact that, okay, director is not available, I still need to run the company, I still need to go ahead and, approve certain important matters. This is where I may sort of think of giving up my quorum in certain cases, which is that, okay, at first instance, you've called a meeting, it got adjourned because of lack of quorum. Now, can that go on forever? No, right? You'll still want to run the company. That's when I will get in my reserve matters, get my affirmative voting matters. Because I'll say, okay, go ahead. Let's say you want to approve a resolution, and I'm not counting the fact that you can still approve resolutions in writing. Go ahead, do the board meeting. Let's say you want to do some administrative sort of resolution which needs to be approved on priority. But still don't decide XYZ matters, which is the list I've agreed to. Because for that, you need to come to me. And that's something I'm interested in. So that's my wish list. Nothing doing. For that, I need to be present at the meeting, or you need to take my consent before the meeting. So that's how we kind of try and build a balance between not hampering the day-to-day operations of a company, but at the same time protecting the shareholders' interests. Okay, so the next subtopic, so to say, here is the board committees. Representation on the board is good, but there are also, and specifically in large companies, a lot of committees which are formed. Now, again, committees can be two sets, right? One is statutorily mandated committees, and the other one could be really operational committees, because let's say it's a huge company with various divisions and all. Not every matter needs to come up to the board unless it's really required. You may have smaller operational subcommittees. Now, do we need representation on all of those? Because, okay, fine, there may be an obligation on these subcommittees to actually come and report to the board. But if the decision making is happening at that subcommittee level, I again need visibility, or I need a sort of, a right to be present in those meetings and actively participate in those decision making. So again, depending on the kind of investor you are, how interested you are, what is the kind of business, or what are the kind of operations that the company is into, you will typically ask for equal representation on these committees as well, both statutory as well as non-statutory. And like I said, the idea is that if there are important matters being taken up at this committee level, we don't want to be blinded at the board level, and we want absolute visibility and participation in decision making there. Then certain other factors that is again linked to board management, and like I said, more important, so to say, in a sorry state of affairs or a dispute scenario is that who will have the right to appoint KMPs, who will have the right to appoint a chairman, does that chairman have a casting vote, what happens if we have equal number of votes, right? Because casting vote becomes important there. Now, KMP's chairman, again, let's divide it into two concepts. You will see that the Companies Act also prescribes for appointment of certain key managerial personnel. And again, that's also linked to certain thresholds. So like only once you exceed your profit of a prescribed ratio, you will have to appoint a company secretary, let's say. Then for a managing director as well. But private, let's say a mid-sized private company may not really have those requirements. So those are probably voluntary positions that you're going to create. But obviously those are important positions. They are the ones who are going to be taking the key decisions. So you again want a right or visibility on that appointment. Now, is that appointment going to be a joint appointment? Is that appointment going to be a reserved matter? Is that going to be purely an investor right? Again, depends on dynamics of each deal, dynamics of how the investor is thinking. In a typical scenario where, let's say, promoter is in majority, you will see that the MD position is going to come by is going to be filled up by the promoter. But a CFO sort of position will actually be probably filled up by the investor. Because like I said, money is important there. And at the same time, generally sophisticated investors will have a certain outlook of how matters, and especially matters relating to your business plan and financial factors need to be run. So they will want somebody of a certain, let's say, qualification or a certain level of experience to be appointed. Similarly, for a chairman now. Now, chairman again is two positions, right? One is a chairman of a board and chairman of really the shareholders meeting. These are things which you will find mentioned in the Companies Act. And then chairman in general. So often it happens that people confuse these two. But strictly from a Companies Act perspective, chairman of a board or a shareholders meeting is actually interested with a little more responsibility in terms of calling the meeting, convening the meeting, signing the minutes of the meeting, etc. So now that's where you would probably want a little more skin in the game sorts, because you would say, okay, if it's a 3:1 1 or 3:2 sort of board where 3 are promoter directors and 2 are investor directors, it shouldn't be that the chairman is always appointed by the promoter. So in those scenarios, you will see that the chairman role sort of kind of moves from the investor to the promoter and vice versa. And then again, from let's say a financial investor perspective, you don't really want to get involved in all of these administrative work, so you're happy with the promoter director continuing as a chairman. Now the other facet of this is, does chairman have a casting vote or not? Again, obviously if it's a balanced board where let's say two directors are there, so obviously there is a possibility that there may be a split scenario where you really don't have a clear majority, and the casting vote of a chairman becomes very important then. But obviously if it's something, let's say there are 4 promoter directors and there's 1 investor director, that's really of very little significance, frankly. But in most cases, the chairman will not really have a casting vote. That's at least what the investor will ask for, not obviously discounting the fact how your board really looks like. Okay, the one thing that I want to actually also touch about is purely, very linked to the Companies Act, is that you would see that now under the Companies Act, there is also a detailed set of secretarial standards that the Institute of Company Secretaries come out. And those actually kind of address a lot of gaps which otherwise were there under the previous company law. And that goes into very minute details of how your minutes need to be maintained, how your registers need to be made, how much a notice period is. So like a very small thing is, let's say the Companies Act just says that there is a 7-day notice period requirement, right? Now does that mean 7 clear days? Does that mean you discount the day you're sending the notice and the date of the meeting? So very, very finer aspects which, you would typically not really see, but once you've done, let's say, 1 or 2 of these agreements, or let's say you've looked at it a couple of times, you will probably know. So like I said, each time you're doing up these provisions, you'll have to probably go back to these to see, okay, I'm agreeing to 7 days, but do I have enough time or not? Okay, I'm agreeing to a shorter consent notice, but what is actually the requirement for convening a meeting at shorter notice? So very small aspects, but again very important in terms of how actually the company will run, how these meetings etc. will be convened. Okay, so we've spoken a lot, I think, about the board meetings, and typically you will see that obviously the board meets much more often than the shareholders, and mostly in a large company. The shareholders meetings, obviously mandated under law, is once every year, where you actually need to come and approve the accounts of the company. But obviously there are other matters which are reserved for the shareholders of the company to approve under the Companies Act as well. So if your articles need to be amended, your registered office needs to be changed, so very important matters still need to go to the shareholders. Similar to now board representation is shareholder meetings representation. Now it's typically simple in a purely normal equity share with no differential voting sort of rights, that 1 share is equal to 1 vote, right? But is that enough? Not really, because let's say there are only corporate shareholders. So if there are only corporate shareholders, you will still want to mandate necessary quorum requirements, where you'd say that the authorized representative of one company needs to be present to constitute valid quorum for a shareholders meeting. And again, the interplay here it becomes important of somebody who's on the grounds. If there are individual promoter shareholders, their presence is very easy, right? You can just typically these meetings will be at the registered office, etc. But for a non-resident entity or an investor, you actually need to find somebody who will be available to attend those meetings and to represent them at those meetings. And which is why, like I said, the quorum at even a shareholders meeting becomes equally important. again, here there you would see the Companies Act does provide a bit of flexibility to private companies, where private companies can actually prescribe for and deviate from the Companies Act requirements, let's say a 21-day notice, having X number of requirements for a notice, etc. So from that perspective, again, you will need to go back, pick up your Companies Act, see what are the exemptions which are available for a private company. Do you have any flexibility or room to, prescribe for something less or strict? So again, you'll have to go back to the book for that. Okay, so I'm going to talk about the veto matters and affirmative voting matters, but before that, we have another poll for you, and you'll have to go back to the Mentimeter. So the facts here are that this is a 50-50 JV company. There are basically 2 directors nominated by each set of the shareholders. The company is in need of funds, and the company is basically voting to decide at the board level whether it needs to raise more money. Here one of the shareholders, which is company A, does not really want to support this because it does not have the funds to really infuse more money into the company. And obviously it's not in favor of this, because if the other shareholder is willing to put in the money, that's going to dilute its percentage in the company, because right now we're at 50-50. Now, how should the director who's has been nominated by this company A, which doesn't really have the funds, vote for this particular matter at the board meeting? Sorry? Who doesn't have the funds, yeah. Okay, I think we do have a majority for against the matter. Then a fair bit of people who are saying that he should abstain from voting, and okay, a few for in favor. Okay, now this is typically a conflict of interest scenario, right? The company needs funds, but you have been nominated by a shareholder who does not have the money to fund, so you're in a fix. Now, ideal world scenario, and looking at, let's say, the codified duties now of a director, he should definitely act in the best interest of the company, not just think about the nominating shareholder, right? So acting in the interest of the company, he should actually be voting in favor of the resolution, because the company needs funds, the company is growing, but obviously that goes against the nominating shareholder. And that's where my board seat is coming from. So obviously the shareholder has the right to appoint, or has the right to remove the shareholder to the director. And obviously, playing a safe bet, you would abstain from voting. Now, how do you kind of legislate for something like this? So this is where, and I'll just go back. Is where your voting matters come into play. Now here, typically we will see one set of really veto matters, and they are sort of descriptive enough to cover all key matters: financial, operational, day-to-day running, important expansion matters, so to say. So if the company wants to do a new line of business, etc., etc. So you would see that in certain cases, the reserve matters are sort of worded in a way that you will need consent not just of the director, but you will actually need consent of the shareholders. So for something like raising funds at the company level, you actually make it a affirmative vote matter at the shareholder level, and so you will actually have to go back to the shareholder. So while the director may vote for or against it, I am going to be deciding whether the funds, basically whether the company will raise funds or not. So I will kind of, yeah.
So what comes to mind is, so the previous
participate, but not block it really.
Participate, do that, and that's where. So I'm just thinking if you could
Sure.
give perspective on what happens if it's not a 50-50.
Hmm.
How do you deal with voting, affirmative voting rights when it comes to rights issues?
Sure.
So Nimisha is actually quite the right person to talk about Byju's, but why don't you go ahead?
Yes, I've worked on the matter, so.
Go in court actually. So I'm
Yeah,
very curious.
yeah. So maybe you can just take it off the facts.
Yeah.
And yeah.
So, preemptive rights, and like you said, if you have a right as an existing shareholder to subscribe to shares, why would you kind of block it? And then what do we get out of it? We'll cover like preemption and anti-dilution later, but strictly to answer your question, I think the one thing which is very important, and I in fact had to touch upon this now, is you will have a business plan, like to start with, one of the ways that you will kind of legislate for it. So, and typically a business plan would be a 5-year plan. So at the time when I'm coming into the company, I already have a vision of what my 5 years is going to look like. And at various stages, I will need fundraise. And so I will start off with an exception for that. So anything which is laid down in my business plan, I have sort of signed up for it already. With the right to participate, not participate, obviously preemption comes separately. So that's one way of really, let's say, an umbrella exception that you can create. Then I think the other way to do it is now how do you balance it, the umbrella exception to actual deviations, right? Because it's possible that in the 4th year it's not actually as per plan. That's not what my expansion plan really had. So we will kind of legislate for that scenario where with again a voting or a veto matter to say that okay, 20 to 30% let's say deviation is allowed. So if I've let's say legislated for $100 million to be raised in the 4th year, but my actual need is $150 million, at least to the extent of $100 million, it's sort of exempted, and I don't need to go back to the shareholders, and that investor, let's say, with a minority shareholding will not be able to block it. So that's one way of really fixing it. The other is obviously preemptive and anti-dilution. Now to some extent, you do have the right to subscribe to a fresh issuance in a rights issue in the company. Again, you as under the Companies Act also, you need, for a rights issue, you need to go back to each existing shareholder. Now, do we say that okay, the unsubscribed portion can be taken up by the other investors or shareholders or not? Or does that mean, let's say there were 100 shares that the company is offering, and let's say 80 were subscribed for, but the 20 that I had to subscribe to, I don't have the money to put in, right? So I'm not going to put in 20. Now, does that pool of 20 become open to the remaining 80 or not? And which is where, we'll talk about dilution a little more in detail. So then at least for 80, you are covered, right? You do get your, let's say, needs to some extent addressed.
Yeah, I just want to add one more thing, Namika, to your question, is that typically in a multi-investor kind of a cap table like Byju's, and I'm going to keep that aside just from a facts perspective, but it's also quite usual to have concepts around major investors and investor majority, which is essentially to say that because now your cap table probably constitutes, let's say, 10% or 20% shareholding of the promoter is highly diluted, and the rest of the cap table constitutes of a number of financial sponsors, then what they would do is designate certain named investors or investors beyond a particular shareholding to be major investors. And either it would, and there are various combinations to it, right? So for example, they will say that, okay, they will even categorize sometimes the issuance. So to say that if there is an issuance beyond, X multiple or of a particular size, then that's a carve out. But for anything else, the approval of, let's say, all major investors are required, or sometimes it will even say a majority of major investors are required. So again, it depends on how sophisticated that cap table has become and really who are the heavyweights. So in the industry, you will see that there are certain big financial sponsors who are together a lot of times. So if you analyze, let's say, the top 10 top 10 unicorns, so to say, you will find that there are certain combinations that will again and again appear in those cap tables, because in some ways, investors are also entrenched. It's a small community. So it's very unlikely in those scenarios that they will have absolutely divergent views. And therefore, they are very comfortable to have these kind of constructs, because they are, in some ways, they consider themselves pretty aligned to at least vote on substantive matters like this. So they will not, like, I don't want to take names, but let's say one of the most active venture capital US based fund, who's mostly there in a lot of these cap tables, and you will find is usually investing together with two others on a number of cap tables. They will always vote together. So in that sense, it's in very remote and very extreme scenarios like Byju's, where people will just start fending for themselves. Because in a Byju scenario, firstly, most of the investors do not have any special rights, and that's why there is this issue. And the second thing is that it's come to such a bad situation that now everybody is trying to just have different remedies and have their own sort of assessment done on what can be done. So yeah, you had a question.
Yeah, so on the voting part, how much do you think the companies will already know how these investors will vote because of the whole proxy voting and the discussions that they have or the press releases they make, that these are our recommendations for companies in say India on these matters, you should vote in this manner. Like what we see with a lot of the, I would say, smaller US investors, that they will appoint one of the proxy voter firms to determine how they should vote.
So I mean, so firstly, on how an investor should vote is not predetermined. But on a practical scenario, what you would see is, it's not like one fine day the founder will decide that I want to raise $100 million, right? Usually there will be discussions around fundraising pretty much in advance at the board level, and based on that, in fact, even the size of the fund is decided as to what the round, what is the size of the next round that's going to be, what are the kind of investors we want to target, whether we want one or we want multiple, whether we want a round which is subscribed at one shot, or we want a round which kind of goes on. So all of these things are decided at the board level by the founders and proposed by the founders to the investors, and it's only after that something is put to vote. But at the time of the vote, it completely depends on what the investors say, usually because they already know that a resolution like this may be tabled. They would have already sort of formed their opinion and formed their view as to where they will stand, and accordingly the voting happens.
Right, and I think that's also, like we mentioned, that you would see that similarly placed investors will actually sort of mostly vote in one fashion. So when you do get like a notice agenda, you have the background documents, you will have enough time to formulate that opinion, to caucus amongst the investors and kind of make up your mind on how you're going to vote for it.
I'd like to make, just based on experience being on some of these boards, is also that a lot of times you would also see that sometimes when these proposals are made, investors also are pretty sophisticated, and some of the investors are pretty entrenched as to what the company's horizon should look like. So a lot of times the investors themselves will, in some way try and guide the promoter to say that, hey, but you may be targeting, let's say, an IPO 2 years down the line or 18 months down the line. So then do you really want to get so much diluted to such an extent? You really need these kind of funds, given that we already have that strategy in hand. So a lot of times it's not simply as simple as a promoter just thinking about, okay, I need this fund and I just want to table it. It will be pretty consultative, and a lot of times, even if there is some sort of a disagreement, the investor would in all likelihood even guide the promoter as to how to sort of raise and maneuver such that the business is also not suffering, and then the strategy of the investor is also intact as far as its own investment hypothesis goes.
I wanted to circle back to the Byju's example, in particular the Articles of Association of Byju's, which lists the reserved matters. Now, it adopts a very broad, subjective language. So, my question is directed towards how to draft these clauses, because if for instance, there is this one portion where they say that any amendment that adversely impacts the investor rights, and that opens up a very large bracket of what can be argued that adversely impacts investor rights. So when a matter, God forbid, lands up in court and then you have to argue on this front, which is a very subjective question. So when one is drafting such clauses, would you advise them to stick to generality, such as such clauses which is a broad spectrum of subjectivity, or make it more specific in nature?
Sure. So, simply speaking, what side are you acting for? You're acting for the investor, then definitely broad rights are welcome. You're acting for the company and the promoter, who actually, wants, let's say, very, very limited interference in running the operations. You would want to box it as much as possible. And that's where you see the last one, where we talk about monetary limits, materiality qualifiers, and certain exemptions. So when we are, let's say we are actually acting for like the company or the promoters, we will actually be very careful of how to draft those reserve matters. One example, like you yourself said, that okay, any amendment of the articles. Now, how do you limit it? I can say that any amendment of the articles which alters the agreed share transfer restrictions or alters my rights to the instrument that are attached, because that's where my dilution, etc. lies. So that's one thing. Second is, I think we touched upon the business plan scenario, right? So I've kind of got a blanket exemption from them that okay, I'm going to follow this book. As long as I'm within the 20% limit, I'm okay. Individual matters, for instance, capex requirements for a company. Now, if you're setting up a plant, you will need obviously money, towards capital expenditure. And you will kind of already factor that in, saying that okay, up to let's say $1 million, etc., you will not have to go back to the shareholders. So from a promoter perspective, definitely a lot more thought is given into drafting. And also, I think increasingly, even from an investor scenario, we are seeing a lot of more sophisticated acts, frankly, because it's really not easy for both the investors or the promoters to have these broad general languages. They would rather have specific things lined up and identified in the document.
Even things like, whether a particular amendment is prejudicial to the rights of, an investor, or whether something is in the ordinary course of business or outside ordinary course of business. You don't try, over legislating and for all of those things, because frankly, a lot of it is fact-based. So, I mean, for example, if I'm getting an investor who is bringing, a higher check, a much higher check than the previous round, at let's say, X times more the valuation, and is simply seeking, a trumping right, let's say, on let's say a drag, right? Is that really in some ways prejudicial or not is something that will depend, right? So are you able to exercise your rights de-horse of the way that this incoming investor is exercising? If that, then how is it really that it is impacting or materially adversely affecting your rights? Similarly, if, for example, the company is now going for an international expansion and is now going to hire, let's say, a big ticket marketing agency which will constitute, let's say, 10% of its expenses, which it has never done. Will you say it's not an ordinary cause, despite the fact that the position of the company has materially changed from the time that you get in? So it's really fact-based.
That.
Okay, so the other key factor of really coming up with your list of AVMs and generally your rights package also sort of depends on the shareholding that you have at the company level, because the Companies Act itself provides for certain protections to shareholders, right? So this is just a brief summary of, you know, the various brackets of shareholding percentages that you will see. So if you're at a 10 to 25%, you have information rights, you have the right to participate in a rights issue, you have the rights to participate in a buyback by the company, you have ordinary notice, voting, etc. requirements. 26 to 50, important because statutorily you have a right to block special resolutions, and which is kind of already key factors prescribed under the Companies Act that you need to go back again to the shareholders for. 51 to 75 is something that again you will see that in a lot of JVs, let's say, even if it's a 50-50, you will see that one partner may probably have a 50 plus one share. And the reason for that one share is actually here, because that means that you will not need the other person to pass an ordinary resolution under the Companies Act. And then obviously more than 75, best case scenario, you except for your veto matters that you contractually agree and other rights which are generally available to all shareholders, you have sort of a lot of flexibility in how to run and operate the company. The one thing before we move on to the next section, on transferability and exit rights, I wanted to really touch on is very briefly on, we've spoken a lot about directors, increasing responsibility, officers in default. How do you actually safeguard the directors then? Because obviously even if you're an investor, not like because of all of these factors, you'll not go ahead and appoint a director, right? So there are a few checks and balances. Like we said, one is obviously whether that person is an executive or a non-executive director. The other is you will definitely require the company to get a robust D&O insurance policy. Generally we are seeing, in fact, even before the investor makes an ask, typically a lot of companies these days have already got it. The third mitigation strategy we typically advise investors of is that please use your board seat and your right of participation in these meetings judiciously. So if you actually disagree with something, make sure that you voice it in the meeting. Make sure that is recorded in the minutes of the meeting, because those are the defenses that will actually help you demonstrate the fact that, okay, while the company made this decision, I was against it. I did not really sign up for this. So, there are ways and means of, even though it may be a risky proposition to have a board seat, but definitely with all of these checks and balances, you can ensure that the nominee director is sort of well protected and taken care of in terms of any liability that may come upon the director. Okay. So we will now move on to the next section, and I'll hand over to Tanvi for that.
So before I start, because this was a really heavy one, governance itself is pretty heavy. So can I just request you all to stand up? Sit. Sorry for all the accidents. And can I just request you to just exchange your seats? We're just going to jiggle a little bit. Thank you, and I'm really sorry for the inconvenience. It's just to sort of shake ourselves a little bit. Before I move on to really getting into the meat of this, I just want to pose one question. And I saw that somebody had actually responded to the first poll on transfer and transfer restrictions and some areas around it. But in the context of a shareholders agreement, why and give and let's for now only talk about private companies, because that's what essentially, most of the the M&A activity, at least that we practice, is about. Of course, when you talk about listed companies, it's a completely different regime, because there's very little in at least in terms of the public shareholders, etc., and for that matter even the promoters, there is a different regime as to how you will govern transfers, because then there are statutory requirements that kind of trigger as you acquire. But from a private company perspective, why do you think that shares which are owned by, let's say, a private party should be restricted in terms of transfer? Do you have any thoughts as to why do we need transfer restrictions at all? Yep. Sure. Okay. So you do not want a third party to get to know what is in the inner, in what is unique to the company, and therefore from that perspective you want to restrict third parties from really buying into the shares of the company. Sure.
Whether it's that you at least get a row 4 or a row 4 in place, so that you get a more representative say in the incoming investor and the nature of the incoming investor. For instance, if it could be a competitor, you would obviously not want their involvement to be increased than your involvement.
Okay. Fair point.
Probably due to incoming of a new investor, the light in which the company is going might change. Like, for example, if it's a domestic based company, it might become more global, and certain investors might not be inclined or might not see potential in the company in that manner. So they would want to have some sort of restrictions or covenants against that.
Okay.
Whether it be a majority investor coming into the picture or whatever, it's just the vested interest that's being protected of the share.
Okay. Similar point.
Maybe you just don't want the promoters to leave.
Yeah, good point. So okay, so let's start, with the meat of it then, and we will cover in some aspects, each of the points that you all made very helpfully. So okay, so just on the transfer restrictions, I think the key to why you need, and I think there are elements to this. There are elements to this that each of the answers said, which is to control who is going to be a transferee in the company, who is going to be a part on the a part of the cap table. Now, when you talk about, and let's think of this both from the perspective of a strategic deal, which is basically, let's say, a joint venture where you have a two-way, three-way party, having let's assume corporates having some representation on the board, bringing different aspects and different expertise to the company, and why would they want to restrict, let's say, an incoming shareholder vis-a-vis a financial sponsor who has put in, let's say, a 10% or a minority interest in the company, and why would he want to restrict, again, transfer of shares by the promoters? So in the first instance, I think the things to think about from a strategic investor's point of view is basically exactly what some of you guys said, right? Which is that each of the JV partners potentially have a particular role defined in the joint venture in terms of what they are going to bring. And in a lot of times, especially when you talk about cross-border deals, you will have situations where you will have, let's say, a non-resident shareholder or a foreign joint venture partner bringing in expertise or some sort of technology. You would see it a lot in a number of joint ventures that are in fact currently happening as well. And therefore, there is a lot of dependency in some ways on those joint venture partners to sort of simply just let them go by a simple transfer. The second thing to think about is also that you would have agreed to you would have had a business plan based on what each of the investors or each of the shareholders are bringing to the table. So for example, if there is a particular shareholder who has who is majority whose majority role is bringing capital to the company, and he is depending heavily, let's say, on the other joint venture partners for execution, technology, or anything else, and simply if the skin in the game starts reducing by that shareholder simply transferring its interest to a third party, then obviously the business proposition itself starts getting adversely impacted or changed, which is what not which each of the shareholders would ideally like to avoid. And then, of course, when you think of it from a financial sponsor's point of view, the idea is that a financial sponsor has basically written a check and invested in a company on the assumption of a return and an exit, based on its own exit horizon. It could be 3 years, 5 years, 7 years, whatever. And the idea is that it's not going to really run the company. The running of the company will be done by the promoter. And the idea is that the promoter is going to put all its time, money, resources to this particular venture to which everybody is basically investing and then ascribing a particular value to. So therefore, if the promoter starts transferring, firstly there is a, in some ways a philosophical question that comes up, that should I get an exit first before the promoter? Because obviously the hypothesis of my investment is to get an exit. So how can there be liquidity given to a promoter before me? So that's a philosophical question. The second thing that is obviously more practical is the fact that the idea is for the promoter to have skin in the game and allocate all its resources to this venture. Not to say that it starts, because the moment the promoter transfers to a third party, there is value that is ascribed to the company which may impact my valuation also, right? So for example, if I have invested in the company at a particular value, or let's say at a particular EBITDA multiple, and the promoter starts selling to a third party, it could result in a variation in terms of whatever the valuation of the company is. Equally, so there is a parallel market being created in some ways to the securities that I want to monetize at some point of time. Secondly, of course, the promoter's skin in the game is reducing. So the idea really is in these kind of financial investments is for further rounds to happen, valuations to increase, and ultimately an exit event to happen, which will give all the investor group an opportunity to exit and monetize. And after that, usually these transfer restrictions on the promoters fall away. Now the next question, the next point that I would like to come to is, when you say transfer, what do transfer restrictions really mean? Or what does transfer really mean? It's yeah, so transfer is not really just the ability to sell, right? But usually when you look at these shareholder agreements, the idea of these restrictions is also to restrict creation of encumbrances, creation of any third-party rights, creation of any liens, entering into any arrangements which give any voting rights to third parties over the shares that are held by the shareholder itself who's subjected to these restrictions. So in some ways these are drafted, and from a conceptual perspective also, they are meant to insulate the entire shareholding of the shareholder to whom these restrictions apply, such as the legal and beneficial ownership remains, but the shareholder cannot deal in those shares in any form, and that's how broadly the transfer itself is worded. And one important aspect to this is also that you will often find the words directly and indirectly mentioned there, because the idea really is that it's not only doing actions which directly sort of in some ways obviate these restrictions, but also not undergo any corporate restructurings, any group level changes, which will again result in a third party getting ultimate interest in these shares. Now, at some times, obviously, when you're dealing with corporate entities, they look at these kind of restrictions also very carefully to assess whether this restriction itself is becoming too too onerous, which can even impact, let's say, global level restructurings. So, for example, if I'm a Nike, okay, and I am getting into some sort of a joint venture in India, which is 1% of my overall revenue globally. While I will enter into these arrangements from a local shareholder agreement point of view, but if the restriction is so broad, which mentions that even if I am to get an investment or a global restructuring done outside on a much broader group level, will that should I come to the Indian joint venture partner to seek a consent? Potentially no, right? So those again, depending on the facts and circumstances and scenarios that you are dealing with, sometimes the carve outs become justifiable and sometimes not. So we will, so that's one thing. The next thing is that when you talk about these restrictions, and let's first talk about what we usually call as the lock-in restriction. And a lock-in is basically an ultimate restriction to sell shares and or maybe transfer shares, and usually apply either for a time bound period or until occurrence of a particular event. So in the examples that I took previously, if it is, let's say, a financial sponsor scenario, it could be a restriction until the exit of the investors. If it is a joint venture scenario where the gestation period of your joint venture is, let's say, a 5 years or a 7 years until when the commercial production is going to start, or a particular milestone in terms of production and commencement would have happened, and therefore there is less dependency on the other shareholders, you would probably have a 5 or a 7 year period depending on whatever the business plan is. The other thing to think about is, I think somebody mentioned about competitors. So that is the next transfer restriction that you would ordinarily find in both scenarios of a strategic as well as a financial sponsor deal, wherein transfers to competitors are restricted restricted absolutely in most scenarios. And of course I don't need to get into why, because obviously we are talking about proprietary information of the company and you don't want any conflict of interest to arise. But the other important thing is to consider who a competitor is, which is the often sort of discussed negotiated point, because from, let's say, if I talk about a joint venture scenario, sometimes if it is something which is really new, for example, a really new sort of a business model or a really new product that you are bringing, it may be that frankly there is nobody of a direct competition existing today. But when these restrictions are meant to apply for a longer period of time on a prospective basis, and therefore in a lot of those kind of scenarios, it's obvious to sort of keep the competitor drafted as something much broader, to say that something a person who is directly competing with the business of the company, or identical business or a similar business of the company. In scenarios where, for example, there are more developed sort of business models, and in some ways from a promoter perspective as well as in fact from a shareholder perspective as well, because even from an investor point of view, while an investor will not agree to any sort of a transfer restriction usually, I mean the underlying principle of any financial sponsor is that I'm not going to agree to any restriction on transfer of my shares, right? Because they are guided by their own investment philosophy, which may or may not change, and they usually like to keep complete flexibility around their transfers. This is one restriction that usually investors also agree to, but at the same time they want to restrict that, they want to limit that restriction to a narrower set of individuals to whom they cannot transfer. So again, it could be a list of identified competitors to whom transfers are restricted. It could be a very narrowly defined business definition, which will then apply to the competitor as well. So there are again different permutations of it depending on your scenario as well as the business. I think the next bit is that while all of these restrictions apply, so there will be a lock-in that applies, and but the one carve out to the lock-in that you would usually see is a transfer to an affiliate. And again, the principle around that is that ultimately if I, as a counterparty, want to do any sort of inter se, corporate restructuring, reorganization, I want to relook at my tax position, because of which, it may be beneficial that instead of a particular entity, another group entity should be holding these shares. Transfers to affiliates should be permissible. They are usually carved out and they are usually permissible. But the principle is that the counterparty should remain the same, which essentially means that if, for example, the transferee affiliate ceases to be an affiliate of the transferor, then the idea is for those shares to be transferred back so that the restriction still applies and the counterparty remains intact, or to transfer it to any other affiliate of the transferor. That is number one. Number two is also that in an affiliate transfer, the transferee is usually, because now you're parting away with the shares and a new investor or a new entity is going to hold the shares. So there is a concept of a deed of adherence, which is basically that once these shares are transferred from company A within the same group to company B within the same group, because from a privity of contract perspective, the company B needs to be party to the shareholders agreement and also be bound by all the other provisions of the shareholder agreement. So company B will have to sign a deed of adherence to be bound by the shareholder agreement. The other thing is that a lot of times, the other shareholders would want to ensure that the primary shareholder or the primary counterparty still remains responsible for any acts or omissions of the affiliate. So that's the other important thing to think about. And again, it comes back to the same principle of having certainty around who the counterparty is. Now let's talk about a couple of, so what happens, let's say, post lock-in. And I think somebody mentioned about having an opportunity to consolidate and keep the shareholding of the company within the defined set of shareholder group, for which you have provisions around a ROFO and a ROFR. So in fact, I saw that some of you had even responded to the poll, around these. But these are usually, a lot of times mixed up concepts. So sometimes, people need to understand the key differences between a ROFO and a ROFR. But the intent remains the same, or the hypothesis around why we need these, a ROFR or ROFR, remains the same, which is to give the ability to an existing non-transferring shareholder to buy shares from a transferring shareholders before it is tendered to a third party. Now the mechanism really differs. So I'll start with the easier one, which is the ROFO, and that is also construed as a little more seller friendly, which is that, so the way that it works is that if a transferring shareholder proposes to transfer their shares to a third party, they will, before doing that, they will offer the shares to the non-transferring shareholder. The non-transferring shareholder can give in a price to buy those shares, and the restriction on the transferring shareholder is not to transfer those shares to a third party at a price or on terms which are more favorable than the terms offered by the non-transferring shareholder. So really the way that it will happen is that if the non-transferring shareholder tenders an offer, the transferring shareholder can, if the transferring shareholder tenders an offer, the non-transferring shareholder can either decide to buy it or not. In case it decides to buy it and gives in terms or a price, then the transferring shareholder can decide whether it wants to just close the deal within the shareholder group, or offer it to a third party outside. If it wants to offer it to a third party outside, it cannot do that third party deal at terms which are more favorable than the terms which have been offered by the non-transferring shareholder. So why do you think that this is considered as more seller friendly? Yeah.
The reason is because any person who makes an offer to the seller, right, they'll be able to, sorry, my mistake. In this matter, they will not be required to make any due diligence, the person who's offering it, right? The first due diligence will happen when the valuation is set by the majority.
Okay. So I didn't get that very
Right.
clearly
So
though.
the first, so in the case, you'll have to compare it to ROFR, right?
Yeah.
To make the
Yeah.
distinction of this being
So you're
seller
saying
friendly.
just in terms of the process, because I'm offering it to an existing shareholder will not do a diligence. So I have done price discovery before the diligence is done.
No, I'm just saying the existing shareholder will not have to create another price discovery mechanism, right? But when you do it in a ROFR scenario, you first get an offer from an outside shareholder who finishes the due diligence. While in this scenario, and then the due diligence will go to waste if a ROFR is accepted. In that sense, if the offer is accepted by the majority in a ROFR scenario. But in a ROFO, what happens is that the party that is majority will have to do a due diligence, and if they're not willing to buy it, then you're free outside and get whatever this one, as long as it's above the base price that's set by the ROFO terms.
Okay. Anybody else? Okay, so I think there are two big aspects to why a ROFO is considered as more seller friendly than, let's say, a ROFO. The first thing, of course, is that you are doing price discovery at the first level, right? Which is that because you have offered your shares to an existing shareholder, if you have to offer the same, even if you don't want to go ahead with that deal, but in some ways the baseline is already sort of set, right? So it in some ways with the third party, you have a baseline price, and there are chances that you're going to get a better valuation than that if you have gotten a favorable response from a third party, because your baseline pricing has already been set. The second advantage of a ROFO to a ROFR is that there is greater deal certainty for a third party buyer. So because the process as far as the transfer regime goes has already finished before you are approaching a third party buyer, it's more likely from a third party buyer's perspective also to give a more genuine offer, because then there is no further, then in some ways if the commercials work, the likelihood of the deal going through for a third party is also greater, vis-a-vis a situation of a ROFR, wherein you just explained what a ROFR is, but just to sort of lay it out in simpler terms, in a ROFR what is happening really is that you can before you transfer shares to a third party, the terms which you have negotiated with the third party have to be offered back to an existing shareholder. So the opportunity has to be given to an existing shareholder to purchase those shares at the terms that are offered by the third party before that deal can go through. So from a third party's perspective, it's often looked as something which has a much lower deal certainty, so to say, because why will, for example, you as a potential buyer of these shares really give a genuine offer when you know that you can always be trumped? So that's why from a seller perspective, it's construed to be a lot more onerous, because it requires firstly two processes, and it's the likelihood of getting a genuine offer decreases, and there is no price discovery that is really happening. So for example, even if you are engaging with a third party, firstly with that deal uncertainty, are you getting a genuine price is a question mark. Secondly, the price discovery has to be done with that third party who may not value the business or see the business as you do. So that's really the big difference. Now, the other thing to think about is also what is usual. So from an investor perspective, you would usually see that that they will never agree to these kind of rights. As I mentioned, that there is very less flexibility to create any restriction on transfers by investors. At the most, you would see as a market practice investors agreeing to a ROFO, again because there is price discovery. But the ROFO is not particularly looked at very favorably by financial sponsors. When you look at it from a promoter point of view, so do you think that these restrictions should also apply to promoters? So if promoters, let's say, want to transfer, should they be subject to these kind of rights? Okay, so again, you have to again think of the basic principle, which is that promoters usually at the transfer itself is completely restricted until the exit. So from that perspective, these become only relevant post exit, in which case, in any case, the investor would have already in some ways monetized. So in a pure financial sponsor scenario, while these may be included from a promoter's perspective for to restrict the promoter, but really the viability and what circumstances these will already or these will play out, you will have to assess. Any questions that you have on the ROFO, because this is an important concept before I sort of move? Okay, sorry, I missed that. So usually what happens is that if it is a multi-party shareholder agreement scenario, right? So for example, let's say that there are three investors, or three investors and a promoter in a cap table, and one of the investors wants to transfer. The usual ROFO right, and let's assume that there is a ROFO that the other shareholders have. So the usual ROFO right will basically act pro rata vis-a-vis all the other existing shareholders, right? To say that the transferring shareholder will offer the transferring shares to all the other shareholders pro rata to their shareholding in the company. Now, in this scenario, what could happen is that one of the shareholders, one of the non-transferring shareholders, may accept, but there may be another non-transferring shareholder which may not accept the offer. Let's assume that ROFO kind of goes through, which is that a price is discovered in the ROFO, and the transferring shareholders decides to transfer the shares within that ROFO mechanism. In that scenario, you would still have certain shares which are not exercised, because there is one non-transferring shareholder which has not exercised its right to ROFO, right? In that scenario, there are provisions included in the shareholders agreement, which we usually call as the mop-up right, which gives the ability to the exercising shareholders to purchase those shares at the same terms, which is in addition to their pro rata. So it's basically to avoid a situation where you have completed this process, but yet there is a stub number of shares which are left out, for which you firstly may not have the market to really go out, and secondly, then the entire sort of the deal kind of falls away for a, let's say, a transferring shareholder who wants to completely exit. So these mop-up rights are given in order to avoid these stub scenarios. Any other questions? So when you say promoter wants, this is in a scenario where the investor is transferring. So the reason why a potential reason why a promoter may say that it should be a ROFR is that it wants to avoid a situation of a compulsive purchase, right? In that sense. So I mean, if I'm a promoter and if I want to restrict who's going to be on my cap table, if I have a ROFO, then it's more likely that I'm going to exercise it in order to restrict, let's say a third party getting into the cap table by if I'm not exercising my ROFO. Versus a ROFR, where it's then incumbent upon the transferring investor to really find a market, find a credible deal, and then come back to me with a more genuine offer, which in some ways, when you say what is a genuine price, it's a price which is already discovered by somebody, for which there is a willing buyer and a willing seller. So this is a price then which is offered to him for which there is already a willing buyer, and so in that sense is meant to be a little more genuine. Okay, I'll then move to the next one. So then I think the next bit that comes in terms of transfer restrictions is what we call a tag and a drag, right? And usually, you would associate a drag along right with a majority shareholder and a tag along right with a minority shareholder. Again, the principle around it is that if a majority shareholder is transferring shares, then, and I'm again going to talk about both from a strategic point of view as well as the financial sponsor point of view. Let's take a strategic first. From a strategic point of view, if a majority shareholder is transferring, then there is likely to be a turn in terms of what the business strategy is. So I, as a minority shareholder who has entered into a joint venture based on mutual roles and responsibilities, would ideally want to tag along and transfer my shares along with the transferring majority shareholder, such that there is liquidity and exit created for both of us, because I'm not quite sure in terms of how the business will be looked at and who the majority shareholder will be, or how the majority shareholder looks at this business tomorrow. The second thing is that from a majority perspective, I, as a majority shareholder, usually would want a situation that if I have found a viable deal, which is, where there is a potential buyer to buy majority of the company, then I would usually, retain a right to even drag along other shareholders, because in that sense, there is a viable or a favorable price that is being offered. Obviously, the price is being offered based on control that the incoming purchaser associates with the company. And therefore, this right is retained such that the liquidity is created. Of course, the elements in terms of the drag still remain the fact that the dragging shareholder will have to ensure that the dragged shareholders' shares are also purchased simultaneously with the shares of the dragging shareholders. They are bought at the same price, they are bought at the same terms. But at least in terms of baking up an offer, for a potential third-party deal, that is then that ability and power is retained by a majority shareholder with a drag-along scenario. Now, this drag is actually used in multiple situations as well. So if I have to look at it from a financial sponsor point of view, and of course we are going to come to exit, so you will be able to relate to it a little more. But when we talk about exits, a lot of times drag-along rights are used by financial sponsors as an avenue of last resort, which is to say that the shareholders agreement will provide for particular exit rights and modes of exit. But if all of them fail, then the investor would like to take the reins in its own hand and have the ability to sell across and monetize this company or its investment by also dragging along the other shareholders on the cap table. So in that sense, it's an important right, but it is also set out in a completely different aspect when you talk about investment agreements or financial sponsor type of deals. The other scenario where a drag along you would see used is also in a default scenario. So for example, if there is let's talk about a financial sponsor scenario where there is a promoter which has defaulted. In that situation, the investor would want to keep a drag along so that before there is further damage done to the company, if the investor has found a viable deal with a third party buyer, it is able to monetize its investment by dragging along the founders and everybody else in order to have a complete change of control and turnaround done, and then monetize its own investment. So again, from a dragged seller point of view, as you see, because it's the transfer is happening at the same terms as the dragging shareholder, there is limited ability to negotiate. Exit horizon may differ. So for example, if I am a majority shareholder or a major shareholder and I have the ability to drag the other shareholder, and which includes even a recent check that has come at a much higher valuation, that is subject to then a drag, which means that 1 year down the line, if I'm exercising this drag, the real premium or the real gains that investor would have envisaged out of this investment would have failed completely because it has gotten dragged. So there are again, those kind of aspects to sort of think about, and therefore what becomes important is the trigger. What will trigger the drag? And again, it will differ as per scenario. Who can exercise the drag? So is it one investor? Is it investor majority? Is it a major investor? Is it a majority shareholder in a JV scenario? So who can exercise the drag in what scenario? And of course, then there are these terms around simultaneous transfers, same price, etc. The one additional thing which becomes important is that in a drag sale, who's going to give the reps and warranties? So usually, in a investor types in a financial sponsor scenario, if the drag right is retained by the investor would say that that it will only give warranties in relation to its own capacity, authority, title to shares, tax, but all the other warranties will be given by the company. So sometimes it is detailed to that extent. Similar situations in a tag, again, as we spoke, liquidity along with selling shareholders, there is benefit of control premium, and therefore it's a right that the minority wants to retain. And of course then in both the drag and the tag there could be sometimes regulatory hurdles as well. So for example, if the completion of such a transfer to a third party requires consents from regulatory authority, you would also find provisions in both these clauses which will say that the time required, or the closing period which is envisaged in these provisions will be extended to the extent of time required to take these regulatory consents. So I'm just going to move then forward, unless there's, yeah. So a tag, so as the name suggests, it's a right? So a tag along right is a right that I as a minority shareholder has, where in case a majority is transferring shares to a third party, I can tender my shares in that deal, and so the majority will have to also account for the shares that I want to transfer, or I want to exercise my rights to, while it is transferring its own shares. So it's a simultaneous transfer that the majority will have to ensure to the third party, taking into account the shares that I want to tag along for at the same price and at the same term. So it's a right of the tag right holder. It's an obligation of the transferor to ensure that the tagged shares are getting transferred. So that's that. Again, from a drag along perspective, similarly, a drag along right is a right with the whoever is holding, or the dragging shareholder. So it can require the other shareholders to transfer together with him. It's an obligation on the other shareholders to then transfer their shares to that third party if the drag along right has been exercised. So if you read the clause, it says it in as many words, which is that then the dragged shareholders are obliged, or they shall transfer their shares, they shall do all required actions in order to complete the transfer. So, I mean, see, a dragging shareholder, it's firstly, drag along rights are not very commonly exercised, and I think there are very fewer examples of a drag along right being successfully fully exercised. There may be notices, etc., that as a tactic a particular shareholder may serve, but in a lot of situations they are mutually decided and settled for. But to just answer your question, really, I mean, it depends on who the pricing guidelines applies, right? So for example, if it's a dragging shareholder itself that the pricing guidelines apply, then obviously it's going to stitch up the deal which kind of already addresses the pricing the pricing guidelines issue. If it is an issue that actually applies to some other shareholder or dragged shareholder, the dragging shareholder will not care, right? As long as its own right is being exercised, it will exercise its right. And then, of course, for the transfer that is to be done by the dragged shareholder, which is then restricted on account of the pricing guidelines, they will have to find mechanisms to get that transferred through. Or it will not simply drag, right? It will only drag the shareholders, which will enable the transfer to smoothly happen, rather than getting the deal itself struck on account of pricing guidelines which apply to some other shareholder. So again, it depends, right? Like I gave you the scenarios of where you will find the drag. But because I think your question is more, from a JV perspective, usually you will have a drag along right if there is a change of control. There will be seldom a drag along right where it's 100% sale offer. It will usually be that if there is any it's because it's broadly worded, right? You can't really pinpoint the kind of deal that will come through. So usually it will be worded to say that if there is a transfer of shares by the majority that is envisaged, which will result in more than 51% of the company of the shares of the company or the issued share capital being transferred, then the majority shareholder will have the right to drag. So it depends on how it's worded, but in terms of scenario, that is the one that is more likely. Yeah.
I think it's a little similar to his question, but I was just looking at the position that the drag seller is forced to take, and apart from the conditions you listed out, like what would be the events that would trigger a drag situation? Like, is it just what you mentioned, or?
So usually so like if I have to again, think of it from a financial sponsor point of view, it's two situations largely. First situation being that exit events have failed, and then the last resort is a drag. The second situation is that if there is an event of default or a cause of a promoter, then they would like to keep a drag. In a joint venture scenario, it differs slightly, right? And in those scenarios, firstly, it's usual for the majority to have this drag, and the drag to be exercised, let's say if there is a deadlock situation or an event of default by the minority shareholder, etc. So those are the usual situations of a drag. So I mean, the way you think about it is drag in some ways is looked upon as a very draconian right? Because in some ways you are forced to sell your shares at a price that you're not even sort of governing or not even agreeing to. So it's heavily negotiated. Like even from a minority perspective, they will really like to limit the circumstances in which a drag is really exercisable. From a financial sponsor point of view, it's more established in some ways because there are trends in the markets which are more available. So these are the two scenarios that you often sort of have a drag. Yeah, so that's actually a very good question, because the way that it works is, and in fact the provision also provides, is that if the purchaser requires a certain number of shares to be purchased, then in some ways it's prorated, right? So there is a concept of a pro rata tag versus a full tag. And I didn't want to go into that complexity, but because you've asked the question, I will just sort of address that. Often you would find a concept of what we call the pro rata tag. So let's say that there is a purchaser who wants to buy 100 shares. Okay, the transferring shareholder itself has 100 shares, so it has stitched up a deal to sell its own 100 shares to the buyer. Now let's assume a scenario that the other shareholder, the non-transferring shareholder, has a tag, and it has 20 shares that it also wants to transfer. In that scenario, for those 100 shares, basically there will be a pro rata that will be done between, let's say, the shares which are held by the non-transferring shareholder and the transferring shareholder in the company. and accordingly, the ratio will be decided, and for those 100, instead of the 100, the transferring shareholder will sell a little lesser in terms of its own prorated number, to account for the number of shares that the non-transferring shareholder has to transfer. So that is typically what is a pro rata tag. What happens is that, what usually in circumstances where there is a transfer being done which will result in a change of control, or it is a transfer of more than, let's say, 50% of the shares held by a transferring shareholder, then usually the non-transferring shareholder will ask for what is usually called this change of control tag or a full tag, which means that if you are transferring shares to a third party, which is resulting in a change in control of the company, or you are transferring majority of your shares, then I don't want to stay in this company as a shareholder, in which case I want to exercise what is called a full tag, wherein I have the ability, or the tag holder has the right but not the obligation to tender its entire shareholding to that third party. So before, when you stitch that deal with the third party, which is resulting in a change of control, that should account for the right that is available to the non-transferring shareholder to fully transfer its shares in that deal to that third party. Yes, yes, absolutely. And so you will always stitch up the deal like that, right? So it's not something that is coming to you as a surprise. For a person who's transferring, they already know the transfer restrictions that are there. So they will always account for scenarios where if tag is exercised, what will happen, or pro rata tag is exercised, what will happen, if tag is not exercised, what will happen. So in that sense, they will stitch up a deal, to account for that. So usually in those kind of deals, because the first step is the term sheet, you will say that the transfer will happen of at least these many number of shares, and maybe up to these many number of shares with that third party, because the third party has also looked at the shareholders agreement. In that situation, what you would usually have is a full tag, right? So if it is selling a big number of shares in order to completely exit the company, then it will account for its own 100% shares, and also account for the 100% shares that the non-transferring shareholders has the ability to transfer by exercising its full tag. So again, when you are stitching up your deal with the third party, that will be for the number of shares that I have, or I intend to transfer, up to the number of shares that also accounts to the tagged shares, or the shares held by the tagged shareholder. No, it's always because he's. In fact, what will happen is that, let's say the buyer intends on buying X number of shares, okay, and it wants to, which will not give the ability, let's say, to the tagging shareholder to fully exercise its right of a tag. In those situations, what we have also seen, and those are corner cases, is that some number of shares are liquidated. So for the tagging shareholder, some liquidity is granted, and for the remaining shares, there's a waiver taken to say that the tag along right is being waived by you, because you're getting monetized to some extent by virtue of this deal. So in a public listed company, firstly, transfer restrictions are not permissible statutorily. While there can be private arrangements between shareholders, but a lot of it will then be governed by the public company regime, from the SEBI regime on takeover codes, etc. So it's not as straightforward as simply exercising a tag, because the SEBI process will have to be accounted for in a scenario like that. No, so what we are talking about here, therefore, is purely private company situations. I'll come to that because that's an important one in the IPO. That's when really, you know, there is a conversion of a private to a public and then a listing happening. And that's an important, you know, avenue of exit where we are actually discussing the same question, you know, addressing the question that you have. So just bear with me on that one. I'll just continue now. Okay, so here we have now a case study. I'll leave you ahead. Okay, so is that enough, Nimisha? Okay, so I'll just call out the facts for you. Assume that you are a strategic investor investing for 30% stake in a company with an investment horizon of 3 to 5 years. What are the share transfer restrictions that you would negotiate with the promoter? So you're an investor. There's already a a running business. You are coming in late. You are investing 30%. You are subscribing to 30% of the company, and you are negotiating a shareholders agreement, assuming that you have an investment horizon of 3 to 5 years. So I think pretty much on the same lines that we have been discussing, except I would pick, you know, a couple of points from here. So the first one that I would like to pick is, you know, a number of responses actually refer to the ROFO or the ROFR. We are talking about a situation where there is a 30% shareholder, right? In a ROFO or a ROFR scenario, um, the, the right that you are seeking is basically to buy the 70% if the 70% is transferring or proposing to transfer to a third party, right? Which is very unlikely because firstly you're not the one who's running the business. You are an investor. You will always depend on the promoter to run the business. So a ROFO or a ROFR may or may not. I think a majority of you are on the same lines, is to restrict any transfer by the promoter, which is then the lock-in, and then have a tag-along right if the promoter tomorrow wants to transfer, so that there is liquidity also created for you. I think so that's the first one that I wanted to pick on. The other one that I wanted to also take is the vesting period. I think somebody has interestingly mentioned the vesting period. And I didn't cover it because it's a little more complicated, but a vesting period essentially is a restriction or a contractual arrangement entered into with the promoter to say that the shares which are held by the promoter will start vesting on the promoter after a certain periods of time, which means that there could be two aspects to the vesting. The first aspect to the vesting is that while you as a promoter holds those shares, you cannot transfer those shares until those shares start getting released. So these shares are restricted, and let's say after 2 years X number or X percentage of the shares will get released, which means that you will have now the ability to transfer those shares. So this is in some ways a more diluted version of a plain simple lock-in, because a plain simple lock-in is an absolute restriction on transfer. Here you are giving a limited avenue of transfer, but of a significantly lesser percentage held by the promoter. The other aspect of a vesting is even to extend such a restriction to the economic rights which are associated with these shares. So you will say that these shares, while they are held by you, are completely restricted, and as they start getting released is when you will even get economic benefits to those rights. Until then you simply are just registered owners to those shares, but you can neither transfer those shares nor derive any economic benefits to it. So that's again an interesting one, and is often used in situations, in a financial sponsor situations where promoters have vesting schedules, etc. But a lot of times, of course, from a promoter's point of view, they will always argue that these are shares which are already earned by us, or are shares that for which we have already paid for and built the business. Okay. Okay, I'll just go back. So we can move to the next one. Should we? Yeah, sure.
Promoter vesting, but dividends were declared. So what happens to those dividends? Because promoters can't get the shares which are.
So usually the dividends will not get declared. I've not seen a situation where dividends are declared, and because from an investor perspective as well, they would always want to accumulate and put in the money back in the business rather than distributing. So in a situation, I would assume that if there is dividend declared, but there are shares which are subject to the vesting, or they are not released, in that situation it will still be distributable dividends, but paid after whenever the vesting, and then obviously subject to the Companies Act.
Thank you.
Yeah, I think we can take a 5-minute break and then start with this, because again this is a heavy one.
All the students are requested to be back by 12:50. Don't be later than that.
for a strategic investor. So, as I mentioned to you, financial sponsors have invested in a company from the perspective of financial returns, because largely these are investment vehicles and pools which are used, to sort of collect, to have a collection of pool of money, and then that is then invested in these different portfolios, and they are guided by their own fund documents in some ways to then have a definite strategy and an avenue as well as a horizon to really extract and monetize these portfolio investments and return back the money or distribute money to their own investors. And therefore, from that perspective, the mechanism of exit, the horizon of exit, the mode of exit, all of that becomes very, very important. So as I was mentioning, these are the various considerations for packaging, what an exit package would look like. So from an investor's perspective, what is the investment horizon? What are the rights that the investor is getting vis-a-vis other investors? So let's assume a situation where, there is a late stage investment happening, which is in a company which is likely to go in an IPO and there is already a lot of public news around preparedness of the company for a potential IPO. In those kind of situations, really the focus of an investor will be in rights related to that particular exit mode rather than anything else. Obviously, market conditions play a role. So, let's say that we are we are at a time that, let's say, markets are booming, financial markets are booming. Most of the companies are looking at listing at some point of time. So therefore, now you often see investors also negotiate their IPO rights, much more. Or for that matter, if there is a company which has lesser avenues just on the basis of the business that it is conducting or its own financial status of going in for an IPO, or just its size. Let's say the size of the company is not big enough to really tap into public markets, and therefore the natural exit for an investor, let's say, is a sale of its shares to another investor or a secondary deal. So market conditions therefore have played a role in order to guide that investor and move that investor to really look at those investor or exit rights that are relevant for its own exit strategy for that investment. Of course, valuation plays a role. The transfer restrictions themselves play a role. So for example, if inter se shareholder rights are restricted in a manner that that there are very, in some ways, limited avenues of how an exit will be really culminated based on the an investor majority, etc. In those situations, again, as somebody who does not have representation, let's say, in an investor majority, will have a different perspective to the way that it is negotiating its exit rights. And of course, regulatory and tax requirements play a role. So when we come to some of the exit modes like buyback, there you will see that because of the regulatory conditions or the statutory conditions around it, it's a mode which is very less used firstly, and therefore very less negotiated and focused upon. So I think before I go into the secondary sale, I will pick up the IPO, because usually right now sorry, go ahead.
IPO underpricing is a phenomena we see across capital markets, right? Only thing is, with the new age tech startups, I have been observing that initially the price it lists and then it starts going down. So somewhere the market is correcting, right? So what exactly is prompting this overvaluation of stocks in these cases, like whether we talk about Paytm or Zomato, right? To my mind, it is because these investors are getting an exit, the prices are getting overvalued. But is there any factor, do you think, that is going into this valuation that is prompting the overvaluation of these shares?
So a lot of times, valuation itself is driven by demand, right? So the way that the valuation is fixed up for an IPO is firstly based, as you rightly said, is on a particular exit price that, let's say, an investor is looking at in order to monetize. So an investment banker who is appointed for the deal to market the issue will be aggressively sort of trying to sort of get that price, because that's on the basis of which it has potentially gotten the mandate in the first place. So as you rightly said, the fact that there are financial sponsors and they have a definite return, look out for a return, that does play an important role, of course. The other thing is also that in relation to it also is a factor of trends. For example, if there is a trend, let's say, of an IPO fetching, let's say a 12x EBITDA in a company in a particular sector, then that's on the basis of which bankers also start marketing that, pricing that issue and marketing that issue. Whereas then when it lists in the market, again there could be various there could be various factors of the downturn. So it may not be simply a factor, it may not be simply a case of just correcting and then the value was so blown up and then the market has corrected itself. It could be on account of global factors. For example, your geopolitical issues, etc. How do they, how does that impact markets globally and therefore India? It could be on account of a regulatory change. For example, if it is a fintech sort of an IPO and suddenly there is a new fintech regulation which has come, which kind of questions the business model of that entity, then that may have an adverse impact on the valuation and that therefore impacts listing price. So there could be various permutations and combinations and reasons for market correction or price downfall. So I would not totally attribute everything to an exaggerated offer price because it is investor driven, but of course that plays an important role when bankers really price a deal. So I'll basically start with an IPO as an exit mechanism. Before I go that, on the exit per se, when you look at any shareholders agreement, there are certain aspects that have to be thought about. The first thing is that when can and who can trigger an exit, right? So you will usually find that there is a general exit provision, and then there are mechanisms or modes of exits that are prescribed. So on the general exit provision, important thing is when can the exit be triggered. So you will have, because let's say if you're talking about a company, right, and usually it's the obligation of the promoter or the company to fetch an exit for an investor. There has to be a substantial timeline given before, let's say, an exit can be triggered such that the promised return can be given. So it can't be that an investor puts in the check and the next day there is an exit, an exit process that is initiated. That may be counterproductive for the company. It could be counterproductive for the investor itself, because let's say the investor has priced in the deal based on a particular gestation or increase in value that it foresees in the company, and then it foresees its exit. So therefore there is usually a time period after which an exit can be triggered. Equally so, there is a time period for the exit itself, which is the end date or by which an exit has to be given. So usually it will be somewhere in the range of 3 years, 5 years, 7 years, depending on at what stage the investment is coming in. The other important or interesting aspect to it is that let's say there is an investor that comes in and has a shareholders agreement which is negotiated with an exit date of 5 years from the date of the closing, or 5 years from the date of the first closing happened for that investor. Then you see, let's say a year later or 2 years later, there is another round that has happened, okay, and you have the same shareholders agreement. Will there be a reset of this exit period or not? That is again an interesting part. So for example, an incoming investor may say that actually there should be a reset. Now I have come in at a much higher value. I am looking at this company to fetch me an exit of this much, because there is the reserve price has also increased for that investor. The company will say that okay, but now based on the business plan, therefore I am planning for the exit to be 5 years henceforth. So a lot of times even the reset of the exit date is negotiated between the promoter and the investors. The next thing is also generally from an exit perspective to think about what is the level of obligation of the promoter to give an exit. So there will be various permutations and combinations that you will see in the market. So it could be something like a hard obligation, which means that the promoter is undertaking to give an exit at a particular price to an investor. Usually that is not very common, because obviously there are various scenarios, there are various circumstances that will play into the kind of exit, the value of the exit, etc. And so no promoter can really underwrite that, this is the value and by this time I'm going to give. That's almost like writing, a repayment schedule in a loan, which is not really akin to an equity risk that a financial sponsor will usually take in an investment like this. The second thing is also, who will approve the exit. That's fine. Which is again, whether it is, the exit itself is approved by an investor majority, a major investor, all the investors together. So, so that is again who will approve the exit. The next one is also participation in an exit. So a lot of times you will see that while major investors have the ability to approve the exit, but the participation is available for all investors starting from the seed, because everybody is looking at an exit. So you can't take away their exit right, but obviously the say in terms of what we will go for as an exit mode is probably given to a majority kind of a construct in a multi-party or a multi-shareholder cap table. And the last thing is the reserve price. I won't say it's the most common phenomena, because again, as I mentioned, the trend in the market is for founders to give an exit right based on a reasonable effort basis or a commercially reasonable effort basis, in which case they cannot really promise a price. But a lot of times, investors will ask that at least when you say what was a viable exit, that means the viable exit was of something which gives me a return of at least X%, or X, let's say 3x or 5x or 6x or whatever it is. So at least, based on the entry price, what is the upside I'm getting, at least a minimum base price or a reserve price may be fixed. So then we come to the key, exit modes. One of the most common exit mode these days that you see is what we call the IPO or the QIPO, which is the qualified IPO. And it is usually a reserve matter in your shareholders agreement. Again, as I mentioned, as cap tables develop, who will exercise this reserve matter is negotiated, and you may have constructs around investor majority, etc. So the process, IPO itself, as we all know, is a very process oriented mechanism. It is often overseen, it has a lot of regulatory overlay by the SEBI. It is driven by market processes and trends in the market, which is run by merchant bankers. The process itself is overseen by a specialized IPO committee, usually, which is constituted by the committee, by the board, and therefore, from an investor perspective, they will seek a representation in the IPO committee. The additional rights that the investor will seek is obviously deciding the timing, the valuation, which is really the reserve price. Obviously, when it comes to the practicality of it, because the price discovery in an IPO will happen much later after a company files for its draft red herring prospectus. So in some ways, this is more indicative and contractual. But this is only to sort of memorialize the commercials between the company and the investor to really demonstrate that this is really the minimum that they are expecting out of this exit. The other thing to think about is also the issue structure and the approval of the offer document. So these are again additional rights that an investor will seek, and this is majorly focused around ensuring a proper exit, because an exit through an IPO by an investor is by mode of acting as a selling shareholder and tendering its share in the IPO to the public. And therefore they have to ensure the fact that the issue structure is structured in a way that there is appropriate allocation which is given to the selling shareholder in order to enable its own exit. Then of course the right is given to the investors to tender their shares, all or part of their shares, Obviously there will be some statutory level lock-in that may apply, so that is, there is no in overstepping on that, or in that sense, there are no carve-outs, or there are no exceptions to that. That is statutorily required, but there will be no additional lock-in. So a lot of times, as part of the SEBI process, sometimes SEBI requires over and above the statutory lock-in for promoters or other shareholders to sign up to additional lock-in. So which is why there is a provision included that the investor will not sign up to anything additional more than the statutory lock-in that applies under the ICDR. Then one of the most important things that are relevant for any financial sponsor is categorization of the financial sponsor as a promoter. So as we all know, in any IPO there are various liabilities of a promoter on account of misstatement of in prospectus, as well as many other disclosures that go along as far as the promoter go, and therefore from a financial sponsor perspective, that is made very clear in a shareholders agreement that it will not be construed as a promoter, and basically it will not be subject to any promoter lock-ins. It will not be giving any disclosures other than basic disclosures which are required out of a selling shareholder. Now, one of the important questions that somebody I think had asked was that what happens if tomorrow a private company turns into a public company, and therefore the rights which are, or the restrictions which we discussed previously, have to fall away. So this is exactly that scenario, right? Because you're in the juncture of a listing, which is as mandated by SEBI. You will be required to do away with any special rights that are available to any shareholders from your articles of association. And therefore, in order to protect a situation that, okay, firstly my rights are being taken away statutorily, but what happens if the IPO itself is not successful? To account for that, what is put in place is what we call the dilution of rights agreement, or a fall away of rights agreement, or what we call as the suspension of rights, which basically recognizes the fact that these are the shareholder rights which have gotten suspended on account of the IPO. If the IPO does not go through, then these rights will be reinstated back. So for the period of time until from the suspension agreement, which is usually very close to the date of filing of the draft red herring prospectus, until about 6 months time or 12 months time, depending on what is negotiated by the merchant banker, there is a suspension done of the special rights which are available to the financial sponsors. If the IPO is not successful within that period of time, then there is reinstatement of rights that is envisaged in that agreement. Okay. Then I think the next one is obviously there will be obligations on the investor to provide all information, to do everything that is required for a successful IPO. But so these are the these are basically the key aspects of IPO as an exit mechanism. Then we come to the next one, which is what is often referred to as the third party sale. A third party sale is simply a sale of shares which can be triggered as an exit mode to a third party. It is a company facilitated or a promoter facilitated process usually. So a promoter and the company will appoint a merchant banker, where the merchant banker will basically solicit offers for purchase of, let's say, majority or 100%, or a minimum number in order to enable the investor to exit. And then there will be approval of those offers, usually done by whatever is envisaged. So it could be major investors, investor majority, or an investor in case of a single investor scenario. So those offers are then approved. The specific terms of the offer may also be sometimes mentioned in the SHA, which may clarify the fact that these strategic sales or third party sales can be purely for cash with no deferred consideration, can only be for for one time cash. So again, no holdbacks, etc. There should be no side deals, let's say, between the promoter and the third party purchaser. So a lot of these concepts are then drafted in. The other thing is also the recourse. So, like how we were discussing it in the context of a tag along and a drag along, it's again important in a third party sale. In fact, the most important in third party sale to sort of clarify who's going to give the warranties, because any incoming purchaser will obviously want recourse for operational matters as well as the warranties and indemnities, and therefore the exit provision will clarify that the promoter or the company will be giving all operational warranties, etc., and all that the investor will be providing will be warranties around its own authority, capacity, title and tax. Of course, then the costs are borne by the promoters, or sometimes it's shared or borne by the company. But again, these are key aspects when it comes to the third party sale. The last point, which is disagreement with the exit purchaser, I'm just going to take it at the last because that applies to all these exit modes. So I'm just going to pick it up in the last. Then another mechanism or another mode is the trade sale, which is very similar to to a strategic sale that we talked about, except here what we are really talking about is a transfer of any part or all of the business or substantial assets of the company. Now, again, here important things are, how the process will be run, who's going to approve the offer, what are the timelines around that, is there a minimum reserve price that will apply, and again, transaction expenses, how will they be shared. Now, one important question I want to ask and open to the floor for is that why do we think, and if at all, that trade sale is not the most preferred exit mode for a financial sponsor? If you see it, even when we talk about the different modes, and if there is a waterfall to these exit rights, you will see that the trade sale is not really the preferred mode. So can you think of why a trade sale may not be the most preferred exit option for a financial sponsor?
I feel a probable reason could be the financial buyer who's buying it for for making return on its investment is not concerned with owning the assets liability and trying to govern the company part of it. He just wants to
But as an outgoing investor who's looking at an exit, how do you care? You have already monetized. So whether he's able to take care of it, run the business or not, that's not what your lookout is, right?
This is an educated guess, and I think it's from a tax perspective. As compared to equity, where the taxation will be lower, trade sale will attract more taxation.
No, but the tax is on the transferor, and the transferor is the company in this case, right? Because the company is the one which owns the business or the assets, whatever is getting transferred. So how is it a like for like in terms of tax?
I was just thinking that equity sale would attract STCG or LTCG, and this won't. And that's what I was thinking from a tax point of view.
Okay, so I'll come to it. So as you know here, as I mentioned, the transfer is happening of these assets, right, or a part of the assets or the business, where as opposed to a scenario of a third party sale where there is transfer of shares which are happening directly by the outgoing investor. So the difference really is that, firstly, from a commercial perspective, whether you're able to fetch the right value, because usually when you talk about valuation of assets, or a business for that matter, there is, firstly you have a certain book value which is already envisaged. Then you will have a valuation which is prescribed for under the tax laws, where there is a particular mechanism in terms of, a hybrid book value kind of a method. And then you will have to negotiate the pricing based on that. So commercially, what is usually envisaged is that if you are playing in equity, or if you're dealing in equity of a company which is doing quite well, then the likelihood of fetching a better valuation on account of a direct impact or a direct comparable of multiples that are available for that sector in the market are much better, so that those avenues of getting better valuation are there when you come, usually there when you talk about third party sales. Secondly, the transferor in a third party sale, as you mentioned, is the seller, right, or the exiting shareholder. Whereas in a trade sale, the seller is the company. So even if the monetization happens, the consideration will come to the company in this case, and then in turn has to be distributed. Where again there will be firstly a first level of distribution that is required to be done. Secondly, there will also be tax on account of the distribution. So that's the second issue around that. And the third issue is the consolidation issue. So in a third party sale, or in a sale which envisages sale of shares, there of course as we talked about it previously, if it is a substantial sale including a change of control, then there is always a premium attached usually to the control. Whereas when you are talking about, let's say, transfer of substantial assets, then it's only those assets, and the full value of the business may not be consolidated in your deal, and so the deal is actually not getting you the best value on the table for for your investment. Because let's say an investor will usually value the company based on a particular IRR, based on a particular multiple, but if you are translating that, and so usually you will find this term called the MOIC, and I'm not going to go into technicalities, but basically that's the measure of how your returns will be for a financial sponsor. But here then the metric itself from the MOIC is changing, because it's not really now equity. You have moved into the assets and the underlying assets. So I think the drag we've spoken enough about, but it is basically the last avenue. If nothing happens, then usually investors will retain the drag right as well as a right to put, again commercially negotiated. But this is in some ways to take then the control in its own hands, seek offers on its own, and in some ways try and sort of get liquidity. Who should trigger, again, who can be dragged, valuation of a drag, who provides the warranties, we've already spoken about in previously, so I'm not going to go into that again. But the one thing that that I will speak about, which you find more often in a financial sponsor scenario, is what you also call a tag on drag. So usually if let's say an investor majority or a major investor has a drag, and if it is dragging certain shareholders but it is leaving behind certain other investors, then usually those minority investors will also seek something that we call a tag on drag, which means that if you're dragging the others and if you're not dragging me, because I also want to get monetized out of this deal, I also want to tag along to the drag. So that is an additional thing that that is a way sometimes sought by really minority kind of shareholders who may be subject to a drag. And then we come to the call and put options. So again, one of the last resorts if we have to look at them from a financial sponsor point of view. But it is also, again, call and put are also used in other contexts such as strategic investments as well. So the usual scenarios and everybody knows what a call and put is, right? I mean, I'll just for completeness, I will just set it out. So a call option is basically an option but not a right. So it's a right but really not an obligation to require another shareholder to tender its share if the call option holder seeks to buy it. The price itself may also be in that sense legislated for. A put right is basically again a right but not an obligation to require the other shareholder to purchase the shares, so to tender the shares and have it purchased by the other shareholder at a pre-agreed price or a price linked to FMV. So that's the call and the put option, and the scenarios in which they are used is, of course, a put right may be used in the context of a financial sponsor last resort exit, but these are also used in the context of defaults, and events of deadlocks. So in a pure JV sort of scenario, if there is a deadlock, let's say it's a 51-49 JV, and you've reached a situation where there is no going back and you're not able to resolve your deadlocks at any cost, and you want to set your ways apart, then this is one mechanism that is provided for, which is that one of the majority usually will have a call right, or the minority will have a put right, in order to sort of have a viable exit from the JV. Or in case of event of default scenarios, so for example, if there is a particular promoter has defaulted, or a particular shareholder in a JV scenario has defaulted, then what you could also have is to penalize that defaulting shareholder by requiring that defaulting shareholder to transfer its shares at a discount. So you will have a call right at a discount in order to purchase the shares and have that defaulting shareholder ousted from the company without giving him the full value of its shares. Or what you could also have, if you are minority, is to put in your shares. So I don't want to be a part of this company anymore, so I will have the right to put my shares at a premium. So again, but having said all of that, this is all guided by pricing guidelines. If you are dealing between residents and non-residents, then to really exercise these rights, you will have to see whether you are able to sort of satisfy the pricing requirements. So I think we have talked about the triggers. The last thing to really talk about here is that usually for call and put rights, there are also negotiated windows to say that, okay, if you want to exercise your call, or if you want to exercise your put, it's not a right that you have which can be overhanging as a dagger on my head forever. You will have a particular window to exercise that right. So again, that is also negotiated for, and it depends on what scenario you are negotiating this also for. So for example, if it is an EOD kind of a scenario where somebody has defaulted, then it's very difficult for somebody who is a defaulting party to really negotiate that, okay, you can have a consequence only for a particular window. So I think that's really it. I'm going to skip these case studies for now because we are running a little bit behind time. I'll hand it over to Siddharth.
Thanks for that, Tanvi. I think we finally come to the most awaited part, which is the final part. So after this, the idea is that until now, what we've done is that we've seen all these exit mechanisms which Tanvi was discussing. They're all part of a secondary sale scenario where the shareholders are exiting. So while you're getting new shareholders into the company, the actual money is going to the exiting shareholders, right? Because they're selling what they have, the asset is theirs, the shares, which they're selling out. But what is the scenario in which the company needs fresh funds, right? So the company needs to go ahead and the company needs to get more funding. Now, in that scenario, in a normal case, how it plays out is that you can either take fresh funding from new shareholders, that is there. But obviously, with new investors coming in, the existing shareholders will have to dilute their shareholding. So just to simplify it, if you are a shareholder who has currently invested, say, $1 million in the company, the valuation of the company is $2 million. So as on date, you own 50% of the company. But if tomorrow a fresh shareholder comes into place and invests another $1 million, the valuation of the company post money goes to $3 million, and your 1 million only gets you 33.33%. So you no longer have 50% shareholding in the company, or say a majority in the company that is there. So a lot of times what happens is that, a lot of protections are built in within the agreement to make sure that the existing investors have a right to do two things, right? A, control who are the new investors coming into the picture, and B, have a right to maintain their shareholding in the company, right? Also, mechanisms which incentivize shareholders who are continuously and actively committing to the company, right? So if you are a shareholder, say you invested at the time of the seed investment of the company, right? And when there was an idea form, you invested, you were a seed investor, but that's it, right? After that, we've done a lot of rounds of investment, and if you're not investing, but there are other shareholders in the company who've kept on investing in the company, so it also incentivizes those other shareholders. So if you see, if you go into the next slide, why do you need more funds? Obviously, growing entities undertake capital raise periodically. Equity financing is obviously the major part which is there. You can either raise funds through debt financing or through equity financing, right? Now, the idea is that what are the considerations for an investor in these scenarios, right? Dilution of ownership, rights, and powers. Typically, in a shareholder agreement, what you'll see is that your rights are tied to the percentage shareholding that you have. If today you are investing as a majority shareholder, obviously by virtue of having control over the company or having invested a majority in the company, you get a bigger bank rights. But like I said, if you're not investing in the future rounds of the company and your shareholding keeps on diluting, you can't command the same rights that you did previously. So in those scenarios, you have a concept of fall away of rights. That as and when your shareholding keeps getting diluted below a particular threshold, your rights keep falling away, right? Triggers for exercise of preemptive rights. Obviously, from an existing investor perspective, one of the ways to ensure that your shareholding does not get diluted is that you have preemptive rights. Now, it says that what are preemptive rights? They'll say that obviously that whenever the company is going for a fresh round of investment, you go to the existing investors first. Give them an opportunity to invest in the company pro rata their existing shareholding. So basically, if you have 4 shareholders in the company, each holding 25% shares of the company, if I am to raise another $1 million, everybody has the right to invest up to 250,000 each, right? Waiver or assignability of such rights. Obviously, you have a right to waive the right. Existing shareholders have the right to waive this preemptive right if the company wants to raise capital. In most cases, what happens is if you're getting a new investor in, the lawyers will do a due diligence on the company. You see the shareholders, existing shareholders agreement. The shareholders have the preemptive right over there. What you do is you ask the company to get a waiver from all the existing investors and then go ahead with your investment happening. And implications of non-exercise of such right are that, sometimes going forward, you have provisions in the shareholders agreement which says that if you've not exercised your preemptive right once, twice, or thrice, that obviously means you're not willing to actually invest in the future of the company. So sometimes there's a fall away of right, that if you've not exercised it, say twice when the company did a fundraising round or thrice when the company did a fundraising round, then that right falls away. Deed of adherence for incoming investors. So, the idea is that whenever a new investment is coming in, typically what happens is that if you're making a sizable investment, you would want to negotiate a fresh shareholders agreement, right? Because you would want to negotiate fresh set of rights that are there. But what mostly happens is that companies which are doing multiple rounds of investments and the ticket sizes are not that big and a lot of multiple investors are coming in, you make them sign deed of adherences, which basically says that they will get the same rights as other shareholders have in the company, holding the same percentage or the same range of the percentage that is there. So the most important rights when it comes to this, for further capitalization and which help you maintain your existing shareholding are the preemptive rights, right? So preemptive rights allow shareholders to maintain their shareholding. So you can obviously subscribe, like I said, pro rata rights. But in this case as well, as we are discussing in other rights, there is a mop-up right in case of multiple shareholders. Because again, the idea is that you don't want, as a shareholder, new shareholders to come into the picture. If the existing shareholders, out of the 4 existing shareholders, only 3 shareholders are willing to pay their $250,000. So then the remaining shareholder does not exercise his or her right for the preemptive right which is there. So the remaining 3 shareholders will have a right to invest that $250,000 in the same proportion as their existing shareholding. Again, if out of those 3, 2 of them want to, 1 doesn't, then they can go for the remaining one for the third one. But the idea is that they have a right, a mop-up right, just to ensure that a new shareholder is not coming into the picture. Obviously, then what happens is that, typically how it goes is, and like Tanvi was also alluding to it, that you have a business plan in place, right? A company has a business plan in place. Upfront, at the beginning of a financial year, you will agree to a business plan. All the investors, they want to be a part of it. They want to, so typically your agreements, shareholder agreements will say that, say at the beginning of every financial year, the company will formalize a business plan. And then obviously as an investor, you have a right to veto it and you have the right to agree to it. But once that is agreed, that sets out, and you typically, at the time of making an investment as well, you have 5-year business plans in place, or you have all those strategies in place, which set out that, okay, the company will need X amount of funds in order to ensure that, further capital is raised. For those plans, like we were saying, the affirmative voting rights, sometimes preemptive rights are there. So you had said that, okay, this is what you've agreed to upfront. Now, a lot of investors, if they're not agreeing to invest that amount of money, it can lead to a dilution of rights and a follow-away of rights. So I think just quickly, loss of contractual rights, like we discussed, when you see a lot of shareholding rights that are there, rights which are there for 50% shareholders, 25% shareholders, 10% shareholders, they keep reducing, right? Now, what are the typical rights that are there? Loss of contractual rights, appointment of director, observers, AVMs, information rights, and right to cause exit. Obviously, now, if you are a 25% shareholder in a company, you have a right to say appoint 1 director, 2 directors in the company. But if your right gets diluted, then there is a follow-away of right. So typically what we have seen is that, up to 10% you get minimal rights. And if you are a 10% shareholder, your rights will be, in most cases, just limited to a few AVMs, but those AVMs will be just to protect your investment. It's not the type of AVMs which will give you control over the company, but just investment protection AVMs that are there. You can have a right to have a director, but in very rare cases, mostly you get an observer right in those cases that are there. Information rights, yes, because information rights, there are certain basic information rights which you get even by virtue of being just a shareholder of the company, irrespective of the shareholding that you have. So what you need to negotiate is obviously something over and above that, right? Mostly what happens is, see, this shareholders agreement that you agree to, there are certain rights that as a shareholder everybody will have, right? All shareholders will have, dependent upon that slide with Nimisha was also telling you about, that depending on the number of shareholding you have, there are basic rights which all of you have. But what we need to do as a shareholder agreement is to negotiate something over and above that. So keeping that in mind, even as a lawyer, when you're actually drafting those, right? So depending when you actually see that, okay, this is the percentage that my client will end up getting in the company, you need to figure out a rights package, which is obviously at the minimum what you have is already under law. Nobody can take that away. But over and above that, what all you can get, it matters. Which is there. Loss of statutory rights, obviously, why will you not want to be diluted? The same thing which I was saying, that based on the percentage you have. A lot of options which you have, there are some provisions under the Companies Act for which you require a special resolution to be passed, right? A special resolution is that 2/3 of the shareholders of the company present and voting need to vote in favor of a particular resolution for that to be passed. So ideally that means that if you have more than 25% shareholding in the company, then it is that until and unless you don't give an affirmative vote for a particular shareholder matter, those special resolution rights under the Companies Act cannot be passed, right? So that is the right that you have with your shareholding. So you will want to maintain that. So as a shareholder, if you are there, you would want to maintain your shareholding to ensure that those rights are not taken away from you. Or else, if you are getting diluted, then you get those AVMs to make sure that for those matters, at least your consent is taken from you. So this is just an example of statutory rights. You have ability to block special resolutions if you have more than 25%. Ordinary resolutions is obviously 50% because that's majority. Right to call EGM, any shareholders holding equal to or more than 10%. Ability to block general meetings to be held at shorter notice. So basically, a shorter notice is that under the Companies Act, you have the idea that you need to give 21 clear days of notice before holding an EGM meeting, which is there. If 95%, about 95% of the shareholders agree to a shorter notice meeting, you can have it within a day or sometimes on the same day as well. So the idea is that you would want typically your shareholding to be more than that 5% shareholding, so that at least it's not the case that if you're not available or you've not gotten advocate notice, and the company can go ahead and have a shareholders meeting, and then they can say that we were supposed to give you a notice, we gave you a notice in the morning, and we went ahead with the shareholder meeting say 2 hours after that. So that should not be the case. A reduction in participation of future profits of the company, obviously that if your shareholding gets diluted, you will not be able to participate, your percentage participation in the future profits of the company gets diluted. Now there are issuances which do not trigger preemptive rights. So within the agreement itself, you have carve-outs because logically it's you pre-agreed that there will be an IPO. So at that time, you don't get preemptive rights. Exercise of ESOPs, if the employees are exercising ESOPs to get additional new shares in the company, that's something pre-agreed to, which the agreement already sets out. You have a carve-out for that for that you don't get preemptive rights. Splits, consolidations, combinations, recapitalizations, basically any restructuring of the company that will take place. Typically, all these restructurings in any case require special resolutions to be passed, so the majority investors will, as it is, consent will be there. But other than that, these are also instances which you specifically carve out in your shareholders agreement. And then M&A activities like mergers, acquisitions, and amalgamation, so you make a carve out for these in your agreement. That is that. Anti-dilution protection. So now one thing is that I invested in this company when the valuation of the company was 2 million. I invested that another $1 million, and now the pre-money valuation at that time was $3 million. So I invested when, say, the per share price was $1,000, or at a point. Now the next round of funding that the company is raising, it is raising at, say, $500 per share, right? So there's a reduction in valuation of the company. So what I would have gotten at that time, now a new investor is getting double the number of shares for that same price. So this is for this, for a downside protection, what it says that, so you don't want the value of your investment to go down, because the 1,000 shares which were valued previously at, say, $1,000 per share will now be valued at $500 per share. So what will you do? So how do you match up for that? You need extra number of shares. You would want the company to issue those many extra shares to you to make sure that the valuation does not go down. Or typically sometimes what happens is, now that is done in two ways. If you have convertible instruments, right, you have convertible preference shares, which you have. CCPS is a term you sometimes end up hearing, CCDs which are there. So any convertible instruments which are there, even optionally convertible. The conversion formula that is there, you have a formula which says that in case of an anti-dilution event, right, one is a full ratchet anti-dilution. So in which what will happen is, if my previous price per share was $10 and the conversion was happening 1:1, that means the shares were getting converted for every $10 that I had put in, $10 worth shares, 1:1 were getting converted at the conversion price. But now, because the price has reduced to $5 in the next round, a full ratchet anti-dilution would mean that the conversion price simply becomes $5. So that means for every one share that I would put in, I'll get 2 equity shares. Now for every one CCPS, I'll get 2 there. Well, that's full ratchet, right? So that's as simple as saying that the conversion price reduces to what is there in the next round. Obviously, that is investor friendly. So if you are an investor, you have a full ratchet anti-dilution, that is friendly for you. But from a company perspective, what they have and what we typically see in shareholders agreements is what you said, is a weighted average anti-dilution. For that weighted average anti-dilution, there's typically a formula which is put into picture where you will actually have, say, the old conversion price, multiply that with say the outstanding shares plus the consideration which is paid in the new round, and divide that with the outstanding shares plus the new number of shares which are issued. So there's a particular formula which is there. So that gives you a more mathematical weighted average idea of what would have been your conversion price had you invested right now, because the valuation of the company has also increased, the number of shares have increased, or something like that. So that takes a more mathematical way of looking at it. So that's what companies prefer. But obviously from an investor perspective, you just want it to be as simple as the fact that my conversion price is now what the new conversion price is. That is there. Events of default. So obviously now you invested in the company, and you invested in the company based on a certain faith. You invested in, say, the vision of the promoters who were there, and you agreed to this bunch of rights which is there in the shareholders agreement, right? But what if the promoters don't adhere to the rights that are there? The company is not working the way you would have wanted the company to work, or there's certain, you've put in all these You've put in all these transfer restrictions which are there within the agreement, but no, they're not adhering to it. The promoters are going ahead, they're not adhering to the lock-in. So one way is obviously you can go ahead and sue them for specific performance, etc. But obviously that's a long drawn-out battle. The other, there are things like maybe there's fraud by the promoters. There has been a reputational risk which has happened. The promoters have resigned from the company. Many instances happened, and there's a loss of substratum. Obviously the company was incorporated. You had invested in the company because the company had certain targets to achieve, certain things to do. But now it's reached a stage where the company cannot do that. So as an investor, what are the rights would you want in this? So it's an event of default. So there's a default on the other party, right? Now the first thing is obviously you want to run away. You want to run the opposite way. You want to take your money. You want to sell everything off and go. Okay, this is not working out. You are thieves. You've done something. You've done something wrong. The company is not going anywhere. You want to run away from it. So one is those. So that is one way. The other way is you think that okay, I can run this company better. So, these were the promoters who were there now because say they've resigned or they've done some fraud or there is something which is called reputational risk to the company. You want to take over the company because you feel that you can do a better job, right? So that keeping in mind that mindset, those is the type of rights and option consequences that you have. Now, obviously, if you want to run away and you want to just encash whatever you had invested and you don't want to be there in the company any further. So as a non-defaulting shareholder is one of the things is accelerated exit, right? Which can be exercised by the way of put options which we were discussing that are there. Failing that, you can actually drag out all the shareholders which are there, right? So it's simple. Either you buy out my shares. Now you've done what you had to do. There's an event of default scenario. Now either buy out the shares at a predetermined price because at least I should get the minimum amount I've invested plus some return which is there. If that's not happening, you're not buying my company, I'll get a buyer, and then those are the times when I can actually drag out all the existing shareholders, right? So that's accelerated exit or whatever other exit mechanisms that we had and have agreed to under the agreement. So those get accelerated because typically you will have that exit window of 5 years, 7 years, etc. But now an event of default, even if it's happened after 2 years, you want an out, so those get accelerated. The other thing is obviously in the same idea that you want to an ability to be able to sell and get out of the company, you say another consequence is that all the restrictions which were there, right? All the type of transfer restrictions that you had imposed on me now fall away. I have the right to sell my shares to whosoever I want, including a competitor, because I want an out. And because you've not adhered, evidently you've not adhered to anything which is written in the agreement, so none of those obligations should apply to me. So there's a fall away of all those restrictions which are there. The other thing which I was saying was that now the other way of looking at it is that you want control of the company, right? You think that you can do a much better job than what was existing happening. Those are the defaulting shareholders. So as a consequence of that, you say that, okay, all the promoters will resign as directors of the company. I have the right to appoint a majority director of the directors on the company. I also have a right to actually buy out the shares of the promoters, etc., at the lowest possible price, etc., etc. So you get all those actually other type of rights that you have to think about, because then your aim is to then take control of the company and then do whatever you want to with it. But the first instance in that is to chuck them out and take control. And whereas the other rights which we were discussing is when your instance is that you need options to get out of the company and encash your investments. Obviously, when we discuss of all these exit rights which are there, even when we were discussing about anti-dilution rights, right? So just to take a step back, even for anti-dilution, we said that one of the ways is that conversion price gets there. The other is that in a case of an anti-dilution, because you want those extra number of shares, either the company issues those shares to you at the lowest possible price, or what happens is that the promoters are transferring those shares to you. But whenever share transfer is there, and I don't know, so how many of you remember, if you were there for the previous lecture, if you've read about it, there are pricing guidelines and there are pricing restrictions in the country, right? Whenever money is either coming into India or going outside India, any transaction between a resident and non-resident has to be subject to your pricing guidelines, right? Which basically is that whenever money is coming into India, the government wants to ensure that as much money as possible can come in which case you put a floor that you can say that whenever say a resident is selling shares to a non-resident, So at that time, money will come into India when the sale is made. So what will the government want? That as much money as possible should come into the picture. In which case they put a floor and they say that the foreign buyer cannot pay you less than the fair market value of the shares. So that there's no undervaluation of the Indian assets which is happening. On the other hand, if say a non-resident is selling the shares to an Indian party, then what is the idea? Money is going outside India. The government would want to put a ceiling to it. Okay, so in which case the government says that okay, not more than the fair market value. That the Indian resident is not required to pay you more than the fair market value. Now, keeping these pricing restrictions in mind, whenever all of this you are drafting, even say for an anti-dilution, if I am to tell you that okay, the promoter has to transfer the shares to you at the lowest possible price. That lowest possible price is that obviously if an Indian promoter is selling to the foreign shareholders, so they cannot, they have to pay up to the FMV. They can't pay less than that. So that becomes the lowest possible price. And then we need to figure out mechanisms on how to make good that other amount that is there. Similarly, when you also talk about event of default, mechanisms that are there, if I want, to say buy out the shares of the other promoters, but I have to pay the fair market price as well, right? Because then at that case, even if I want to buy out, I'm a foreign investor and I want to buy out the shares of the Indian promoters because they've done an event of default, I will still have to adhere to the pricing guidelines. So to that fact, you have to pay the FMV. So sometimes to counter that on the impact of price, you have something like liquidated damages as well, that for that amount which you are actually paying extra, the company ends up paying you liquidated damages, which are built into the agreement. So the idea, yeah. So see, that's how you do it upfront. See, upfront how I'll have is a lot of times you have Indian affiliates which are there. You can structure it through that way. A lot of these investors already have some Indian affiliates which are there. So in which case you can have the affiliates get that money, or because within India money is not moving out, or what you can even have the sale happening to your Indian affiliates at that case, in which cases your pricing guidelines don't have to there. So a lot of these things upfront when you're drafting, and these are exactly the type of questions you need to ask also when you're drafting something, because keeping those things in mind is how you'll structure your transaction. Because everything, see, one thing is general concepts which are there, right? It is easy to read the concepts, it's easy to do that. The other thing is to draft an agreement which is bespoke to your particular situation, your client, depending on what the client has, what are the, it wants, and what all it needs. I think it's to actually modify it to keep that in mind. So in those cases, you put an idea, you put a concept over here as well, that those can be paid to either me, or I can buy, or any person nominated by me can end up buying it. So in which case you can do an Indian affiliate to buy it out, right? Or if you have, sometimes what you also do is that if the selling entity or the promoters have an entity outside India, you try and structure transactions so that money is only flowing outside India and nothing is coming into India. So then you can again avoid those issues which are there. But having said that, whenever it comes to say India, there's things, the capital account transactions and the current account transactions, right? Now, capital account transactions, the rule is that to the extent they are not expressly permitted, you can't do them, right? Sometimes when it comes to indemnity payments, etc., that becomes an issue to move that money outside India, right? So in those cases, you actually try to structure it as damages. You had that Docomo case where they said that there was this whole thing whether or not it can be structured as damages or not. But you've had contrary judgments also come out from the Madras High Court, etc., where they said that even damages can be linked to the capital that is there. So the best way to then go about is to typically actually structure it in a way that you have affiliates either in India or outside India, and basically either do it domestically or outside India. What these things that you're saying, these are structuring things. Structuring to the extent it may not be to the T, right? It's something you're doing to avoid the law, right? So you're saying that instead of paying it as liquidated damages, you will pay it as a service. You can obviously structure it in a lot of ways. You can enter into a lot of those subside letters or agreements to do that. But I'm not sure if you can actually write that, or you should actually write that in that way in the shareholders agreement.
Additional interesting provision that I've come across is, and I see it used more and more, but it's a recent trend, is what we also call as the nominal put, which is basically that, in like Nimisha's example, where it's come to such a bad situation that I don't want to be associated with that company as an investor, or for that matter, especially especially sovereign wealth funds, etc., who have a lot of policies around things like anti-money laundering, anti-bribery, and things like that. And if those are the kind of issues that have come up in these entities, then the investment itself in some ways is contradictory to the covenants that the investment manager has signed up for its own fund. And in that, to cater for scenarios like that, what we have also seen are situations of a nominal put, which basically is that I have the right to put at the lowest possible value. So I just want to get out of the company. So you as a founder just buy me out at 10 rupees, whatever, as a nominal value, but I just want an end to this. So that's another right. It's in some ways like a poison pill, because you're literally writing off your transaction, but the idea still is to get out of that investment. And so this is an additional right that is put in place.
Point that Siddharth has there, like material breach of SHA, which breach has not been cured, blanket versus specific call-outs, right? So I'm just trying to draw a parallel and understand how you approach in the equity side of things. For debt, lenders, like large debt deals, lenders will usually go in for specific call-outs.
Correct.
They'll want certain defaults to be maturing into events of defaults before all these accelerated measures are getting out. Now for investors in equity deals, how is it evolving? Like, do you see blanket provisions more, or are you seeing a better appetite for specific call-outs?
So it is negotiated, Namika. This is one provision which is negotiated a lot, because from a founder perspective, they don't want any small covenant to really trigger draconian provisions such as takeover of the management, removal as a director, put call, drag along rights, and things like that. So from a promoter point of view, they will always want that you identify what are your key provisions which you will trigger, or which will really be a cause or an EOD trigger. Obviously, you, from an investor point of view, you start with a generic one, but it is more common nowadays to really specify the triggers. You mentioned the particular provisions, a breach of which will trigger or which will be a cause or an EOD, and those are usually things like breach of transfer restrictions, breach of non-compete, breach of AML, ABAC covenants, and sometimes it's also linked to a material claim under the SSA. So that's the one which is negotiated the most, because they will always say, or a promoter's or if I was a promoter counsel, I would always say that you have already accounted for that risk mitigation in the indemnity regime that you have negotiated in the subscription agreement or the share purchase agreement. So I'm not going to give you a double right. But that is one more thing that is sort of, sort of negotiated.
Correct. I think because the idea is, given the extreme consequences that come with it, the promoters and the company also want that there should be a specific call out, going forward, for which you are using it. Because if you have a general language or a blanket provision saying for any breach or any material breach of the SHA, we can trigger an AOD. So I think companies and what promoters also are increasingly pushing back on that. And I think the more nuanced investors also nowadays, when you're actually investing, the position is that investors are okay with specific call outs. But yeah, like Tanvi is saying, there are certain things which they want should be called out. But other than that, I think there is an increasingly moving away from the blanket provisions that are there.
One more thing that I'd like to add is that because of what you are seeing in the market, right, for things like, let's say, a Bharat Pay, right, where you have, those litigations going on and you have a small promoter community, right, all of them are connected in some way. So this one provision, where we are seeing a lot of pushback by the promoters. They want it very specific. Obviously the idea is not to be unreasonable or to sort of justify any bad faith events, but they really want to narrow it down. They don't want situations where aggressive investors have taken a view wherein it is resulting in losing out control on the company.
I think we'll quickly just move on to the other miscellaneous provisions which are there, information inspection and other considerations. So information rights, obviously, as an investor investing into the company, you would want certain information rights irrespective of whatever percentage shareholding you have. As a minority investor, obviously it's become something which is more important because you're not involved in the day-to-day functioning of the company or the day-to-day operations of the company, but you still want to know what is happening in the company, right? And as an investor, why do you need these rights, right? You have access to the health of the investment, scrutinize management action, detect fraud and mismanagement, incentivize responsible behavior, and ensure corporate governance. So you will gamut of things, right? Obviously, if as a promoter and people who are running the company, you know that the investors have oversight on what you're doing. They have a right to inspect your books. They require certain information rights on a monthly. So these information rights can be your monthly information statements which are there, quarterly financial statements which are given. You can even have, say, access to the key managerial person of the company, have quarterly or monthly calls with them to understand what is happening in the company. So the idea is that irrespective of what happens is that as any shareholder, even for the public, at the end of the financial year, the audited financials of the company, the balance sheet gets filed. That becomes a public document. But obviously, you don't want to wait the entire year to get those rights, right? So what you would want is, as an investor, that, okay, I've invested, say I'm a financial investor, I've invested 15-20% in the company. I want my exit return, which comes in after 5 to 7 years, right? I have these rights which are there, those EOD rights which are there, etc. in the company. And so what do I want? I want to know that the company is going in the right direction. We have agreed to a business plan also, right? We've agreed to a business plan. We've agreed to a certain set of permitted expenditures which are there, that the company can do these expenditures. If it does something more than that, then they have to come to me to take my permission. But how do you keep notice? How do you keep a check? One way is that if you have a director on the board, okay, matters which are taken up at board level, they come to your notice, right? But sometimes when you don't have that kind of right on the company, on the board, right? You don't have nominee directors on the board. In fact, even if you don't have observer rights on the board, so how will you come to know as an investor? So you keep these information rights which are there, that okay, on a monthly basis, I need a statement of what the profits of the company, expenditures of the company are, or whatever your business requirements are, depending on the sector in which you are operating. You have those things, right? What is happening, what are the material expenditures which you have done, what are the capital expenditures you've done. So you will require those kind of informations. Now it works in both ways, right? One is obviously from a management perspective, it keeps you on check. It knows that, you know, you are answerable, you have to give these reports which are there. So if anything wrong happens, it can actually reflect and they can check it out. From an investor perspective, you know that the company is adhering to what you've agreed to in the agreement. So if tomorrow you see that, you know, there are things like the, you know, profitability of the company is falling, if the company has made certain material expenditures for which you were not consulted and they were required to consult you on the agreement, or whatever things have those sort of happened, you can only take action if you have information with you. So it's a very important tool as an investor, irrespective of what percentage information shareholding you have, to have this information right. And obviously incentivize responsible behavior. If you see the company is doing well, you can have some targets associated to that as well. These information rights or inspection rights are event based and periodic. Like I said, you can have monthly information rights which are there, which are happening in the company. You can have provisions like wherever there is, you know, any share transfer in the company happening, any shareholder transfer is happening, etc. I should be informed about it, or whatever you have. So you can have an event based information inspection rights which are there, and periodic information inspection rights are there. There is pushback against disclosure of any sensitive business strategies and trade secrets. If you're in a company or in a regulated company or in a IP intensive company or IT intensive company where you're doing a lot of patents, you're doing a lot of coding, etc. is happening, you have a lot of trade secrets that are there. You don't want that, you know, all those things should form part of the information that you're giving on a monthly basis, even to a small shareholder who has minuscule shareholding in the company. So from a company perspective, the idea will be that I will give you information to the extent it is required for you to maintain your rights, to have a foresight into what's happening to your investment. So all those financial protection rights is what I'll give you, but nothing beyond that, right? So obviously whenever we are negotiating these rights, it becomes a very commercial discussion as to what the company is willing to let go of and what all the investors actually need to make an informed decision. Shareholders can negotiate the right to inspect properties, books, records, assets of the company, engage in discussions with employees and management. See, one way is that they give you what they give you, right? They give you a statement. But if you look at it and you blatantly feel that, you know, maybe there's something wrong in the statement or it's not showing the true picture, then you, instead of just the information right, you also want inspection rights that, okay, what? Give me, I have the right that I can send my auditor to actually look at the books of accounts to reconcile what you've given to me. So those are the inspection rights as a check to that information that you're actually getting. And obviously a right access to talk to the employees and the management. Sometimes at the top level, a lot of things can get filtered down. You want to have calls with people who are actually on the ground who can answer your questions in real time. As a majority investor and a minority investor, these change. As a majority investor, obviously the idea should be that although you want a lot of information rights, it should not become a compliance obligation on the company that I actually have to incur cost and employ two people who will only collate this information for you on a monthly basis. So what increasingly the idea is that companies say that, you know, we are willing to give you information, but I will only give you information which I make or which I have with me. Right? And on a monthly basis, I have 5 factories. In any case, I have a record of how much sales have happened from that factory, how many products have been exported from that factory, how many employees are there who have joined, resigned. These are records I keep normally, which is what I can give you on a periodic basis. If there is something specifically that I have to do for you, maybe the frequency can be once in a quarter or, you know, once in 6 months, and I can get it audited and do everything for you. But I don't want regular compliance costs with me. Right? So from a company perspective, that is increasingly how people are pushing back that, okay, we can give what we have and what we normally do, but anything over and above that, it has to make commercial sense. Otherwise, it doesn't make sense that I have a separate compliance officer just to make sure that I'm giving you regular information. That's that. Obviously, as a minority investor, your idea should be that because you don't have board rights, you don't have observer rights, what are the type of information that you need in order to get a smell test that, you know, things are going fine in the company or not. I think just lastly, some miscellaneous clauses that are there. You typically have an MFN clause, which investors say that, okay, I am investing, you know, I have negotiated this rights with you. You've said that these are the rights that you, maximum rights that you can give me as a company. Nothing else can happening. But say tomorrow another 10% investor comes and he or she is getting better rights. You know, they are getting better rights than what I have. So basically what I am saying is that if anybody is coming at better terms than me, those terms should be replicated for me as well. You have them also say, when you have conversion terms in agreements, right? So I have agreed to a certain set of conversion terms in the agreement, but if tomorrow someone else is also subscribing to convertible instruments of the company, so their terms, if they are getting better terms, those should again get replicated for me as well. Non-compete, non-solicit, we did discuss it briefly on how you actually put those restrictions on the shareholders of a company. Now, as investors, see, if you are getting investors in the company, now as a company or a promoter, what would you want? See, you are, okay, I am getting funds from you and you are shareholders. You have access to a lot of confidential information of the company, right? You have access to a lot of confidential information of the company. If you're sitting on the board and some of the board committees as well, you have information to a lot of trade secrets, a lot of things that we are doing. So, what recently happened with one of our clients with whom we are, representing on a shareholder dispute is that she had a company and she had a software company. They were about to bid for this very big project which was there, and they had a board meeting, had discussed about that project, and they said, this is what we are going to do, this is, things that we are going to do, this is how we are going to make the pitch, etc., etc. Now, this person who was the director on the company also had investments, indirectly or some link again with a competitor company. Before they could make the pitch to the client, they could actually do it. They already went there, they made a pitch, and obviously they knew the points which they were going to say. So in addition to that, they sweetened the deal more, and they ended up getting the offer. So that is there. So it is those kind of situations that you want to avoid. You have non-compete obligations which are there, and non-solicit is obviously that you have access to all my employees, all this. You should not be soliciting the employees, because ultimately it's talent which will run the company in the long run. But one thing is that obviously, and these restrictions should not only be on the promoter or the shareholders, but should also extend to the affiliates. Typically, the language we use it, they will not either directly or indirectly engage in these activities. While drafting it, you include their affiliates as well, because the idea is that if they can't do it directly, they should not be able to do it indirectly through any of their affiliates. But the most prominent thing, which is there is the survival of non-compete obligations. In the Indian law, typically the idea is that obviously, restraint of trade is not allowed. You should not do all of those things. But courts agree to a reasonable restriction when it comes to non-compete obligations. Now, reasonable restriction has very different meanings depending on, it's on a case-on-case basis, case-by-case basis that the courts scrutinize it. In case you're an employee, so logic permits that as an employee of the company, it is reasonable for the company to expect that until you're working for me, you cannot work for a competitor or you can't do anything else, right? Or even for, say, after that, if I have to do it, typically for employment cases, post-employment non-competes are not enforceable. Even if they are, they have to be for a very limited period of time. If it's more than that, they don't meet the reasonability test. But if you are a shareholder, now if I am, say, buying a company from you, it's a share purchase agreement, I am buying the company from you. Now, logic permits that because I'm paying a huge amount to buy a particular company from, say, it's a FMCG brand that you had, it's a particular market in which you've been operating for the past 25 years, you had all the know-how, you know everybody. Now, I've bought the goodwill of the company, and I have also bought the company, and I've paid a premium for that. Now, if tomorrow you if today I pay that money to you, and tomorrow you go on to open a rival brand the next day, so that will obviously reduce my valuation. That is, so even from a fairness perspective, that doesn't make sense. So in those cases where you've actually paid the premium, you've bought the goodwill of the company, the courts allow you to enforce a non-compete for a certain period of time. Similarly, for shareholder deals as well, when we try to put, these non-compete provisions, we link it to the your shareholding in the company, as opposed to your employment or any other thing, because for the shareholding itself, it is still enforceable, again for a reasonable period, even post-closing. So even after you've stopped being a shareholder in the company, maybe for a year, 2 years, 3 years, you can push for it, for a non-compete, but nothing beyond that. It will not meet the reasonability test. But again, there's no fixed rule, and again, on a case-on-case basis, the courts do that. fall away thresholds the agreement will deal with, like we discussed. You don't have blanket rights. It's not like once a majority, you have a right to appoint a majority on the board. It's not a right that you have for life. As long as you maintain a certain threshold of shareholding in the company, you will have certain rights. If it falls beyond that, you won't have those rights. What will not fall is, and what you try to carve out is your information rights. But increasingly, a lot of information rights also, you have two sets of information rights which you have in your agreement. One is if you have a little more shareholding in the company, and one is if your shareholding gets reduced, but at least some amount of information rights, like we said, have to be there. So those should not fall away, and it should not apply to tag along right, because even as a because typically, ideally, tag along is a minority protection right? Because as a large shareholder, say if you are an 80% shareholder or 85% shareholder, you are much more likely to get people offers who will want to buy control of the company. You have much more like a reach to get offers from other people. As opposed to a 1%, 2% shareholder, there's not much liquidity because nobody wants to buy just 1 or 2% shares in the company. So even at a reduced shareholding, a tag along right is something you'll want to be maintained, because that's your minority protection right as well. And then exercise of rights in case of partial transfer. There are some of the other clauses which are there is now you are a 20% shareholder or a 10% shareholder of the company. You have sold 2% shareholding to someone else. Right, as part of the share transfer process. So what we'll typically say is that if you've transferred either to an affiliate or to a third party, both of you should be acting together when it comes to the exercise of rights under the agreement, because I don't want to be dealing with 20 shareholders. You've sold your shares to 20 people tomorrow. I don't want to be dealing with those 20 people. So all of you should act as a block when it comes to your shareholding and then exercise your rights, which are there. Lastly, I think we'll just end it with this case study of one of the transactions that we did. So, which just gives you an idea of what all rights you have as a 10%, in that transaction. In a D2C, I hope it's like direct to customer sales was happening in a brand. So this is what was the rights package which was agreed to. So over here, what was there, and because it's a real live case, so just to give you an idea of what is the type of rights when it comes to appointment and voting rights. In that agreement, it said that any shareholder who has 5% or more shareholding, so you have a right to appoint one non-executive nominee director. You get to be a part of the investor majority that is there. What was the investor majority concept is also when you have a lot of these rights, so in companies which have multiple shareholders, right? You cannot give a affirmative voting right to every 5% shareholder who's there, because then the issue becomes, and you may not have one shareholder who has 20-30%, you have multiple shareholders who have small percentages. But if I go on giving an affirmative voting right to say every shareholder who has 5% shareholding, then it becomes very problematic for me as a company, because then I have to go to 20 people every time I want to do something, right? So in which case what I do is I make an investor majority construct. I say that if 25 or 30% of the investors holding 5% or more shares in the company, they come together, they can block an AVM or they can exercise certain rights. So what that gives you is a right to be an investor majority towards affirmative voting items. You can do that. Below that, if you were between 2.5 to 5%, you had the right to vote towards other consent items, right? So what we had in that agreement was that we had one set of larger AVMs, right, which gave you a lot more control, which were, a lot more, some of them were operational AVMs as well. And we had another bucket, which was part B bucket of the AVMs, which were lighter, only financial things, right? You can't as an investor, if I was just to have rights to safeguard my investments, what will I say? I'll say that, okay, you cannot take, for running this business, you require, say, at any given point of time, 5 to 10 crore rupee loan, which is fine, you do that in an ordinary course of business. But tomorrow, if you're taking a 100 crore loan, which can actually have an impact on the company, then I would want a protection right. When it comes to basically just a concept, when it comes to all these rights, there's a differentiation between a right that can give you a control and ones which are just protection rights. So this example which was there in one court case which is there is that if you're driving a car, if you're sitting in a car, you can be sitting in the back seat of the car and some other person is the driver. Now one thing is that you have total control. You tell the driver this is the destination that you have to go to. You can tell the driver to take a right or left whenever you want. You can tell the driver whatever speed the driver has to drive at. in which case, even if you're not sitting behind the steering wheel, you are controlling how the car is working. So you have control. So if you have those kind of rights in a company, you are controlling the company. But the other type of right is that the destination the driver has told you, and this is the roadmap, that okay, this is the map I'm taking, this is the destination that we're going to. Now, if tomorrow the if now the driver is not adhering to the route and trying to take another turn, the driver should take your consent, which is again what a protection right, because I am sitting as a passenger, I would like to know that this is where I was heading to. If I'm not taking that turn, you take my consent. Now you're driving till 100 kilometers per hour, you're driving is fine. But now if tomorrow you want to drive at 150 kilometers per hour, take my consent to do that as an AVM, which is again not control, but just a protection right that you're having. So this is what the court, type of test also which takes to differentiate between the protection rights that you have and when it becomes control. So the idea was that if you are just between 2.5 to 5%, your rights which you can have in AVM get restricted to only those protection rights. And financial protection is what? If the company tomorrow takes an exorbitant loan, then it's an issue for you. Or if they are diluting the shares of the company, then it becomes an issue for you. So on those lines, if they are changing, say starting a new line of business, then they come and take your consent. If they're amending the articles of association of a company, as normally typically as a 5% shareholder, your consent is not required because they'll only need a special resolution. But then they need to come and take your consent. So it becomes a limited set when it came to that. At 2.5% shareholding, if the only right which was left was they could appoint one observer on the board, which is there. And investor majority confirmation of so investor majority as a construct, in addition to AVMs, had a certain other rights that they could confirm the independent director on the board, etc. And then the type of rights which they had as 10% shareholders were, because obviously at 10% they were part of the investor majority, so they get all the AVMs which were there. They could do a drag sale. In case of a drag sale, it said that if say 51% or more, so investor majority in this case was I think more than 50% or something. So investors holding 5% or more shares and cumulatively 50% or more was the investor majority, they could have done a drag sale, non-compete and business exclusivity rights they had, IPO rights were available to them, EOD they could have triggered as part of an investor majority that was there, and obviously as part of the exit they had third-party sale and strategic sale rights. The other rights which were available to them in that shareholder agreement just was information rights, which we've discussed, preemptive rights, liquidation preference, inspection rights, superior rights, exit rights, ROFR we've discussed, exit rights we've discussed, inspection rights we've discussed, free transferability, that as an investor there was no restriction on their transfer other than the fact that they could have not transferred it to a competitor, right? Pro rata full tag along right to any sale which the promoters were doing in the company, and liquidity sale ROFR, that in case there was a liquidity sale happening, they had a ROFR on it. And conditions associated with certain rights, right of third party sale or strategic sale, valuation to provide the investors a guaranteed return. Obviously the idea was that in case a third party or strategic sale is happening as part of the exit, I want a certain assured return. So just to make sure that it said that a guaranteed return should be built in when the pricing the exit. That is there. So yeah, that's it, just a broad structure of what all was there. The idea was also to finish this last portion a little bit quicker than normal. But yeah, any questions that you have? No, so even under the IBC, not everybody's on the same pedestal, right? They have a waterfall of how the money flows. So you will obviously have to adhere to that waterfall which is there under the IPC, but within your construct, right? For all the money has to come to the shareholders. So when the money has to come within the shareholders, to that you can contractually.
And I think the other thing is that you're only talking about a liquidation from the perspective of one liquidation event, which is insolvency.
Correct.
But actually liquidity preference is used in a number of other liquidation scenarios as well. For example, a change of control transfer, complete buyout, a merger or an amalgamation. So some of those additional corporate actions may also trigger a lick pref.
So, with respect to these subcommittees, first question, can individuals function on both board of directors and subcommittees, or do they have to be separate individuals?
Both. In fact, if it's a statutory committee, so in fact, the Companies Act actually prescribes who will be the members of an audit committee or a nomination remuneration committee. And to a large extent, if the company has independent directors, then mandatorily there has to be a balance. So from that perspective, you will have the same board of directors actually on these statutory committees. Anything contractual, you will have more flexibility, so that can be the same set of people or different set of people. So you may actually have like departmental heads or divisional heads actually running it, but then in those the board will sort of set out the charter for how they will work, and there will be increased reporting obligations of those subcommittees to the directors in either a board meeting or general updates.
Now, this is linking to the information part that we discussed. So, I understand that there might be intricate functioning of these committees, but when we come to information rights, so how these committees function, their minutes of meeting, will they also come under the aspect of information rights, or are they something which is not under the purview of that?
Again, there is no statutory guidance to that, right? So it's if you commercially agree to it on under the contract, you can definitely get those. And in fact, see, what you do is that if you have, say, rights to appoint an observer on the board, you also sometimes extend it to the fact that you can have observer on the committee meetings as well.
And through your nominee directors, somehow your visibility on minutes will be there. And frankly, the investor, financial or somebody, they are actually looking at numbers and all. So you'll be actually wanting MIS to come to you, quarterly statements to come to you, rather than just purely minutes. Minutes you will definitely have visibility on.
Yeah, but that's not, again, to your question, the representation on the committee is a separate right than an information right. It is over and above. So if you can get that information out of your representation in the committee, that's fine. But anyway, your information right subsists. So you will be able to get that information if that's not been a part of the functioning of that particular committee. So thank you so much. I know we started a little late, for apologies for that. And I hope you found this session interesting. I think a lot of what we discussed was in some ways pretty narrow. But when you start reading up a little bit more about inter se shareholder rights, you will find that there is a whole lot of like a different regime, let's say, on the same aspects, if you think about it from promoter's perspective, or if you think about it from based on different stages of investment, or if you even think about it from the perspective of a specific joint venture situations. So there it's a whole lot. I think this was only a very, very preliminary primer. But in case you have any other questions, just feel free to sort of reach out to us.
In fact, if you actually check out on YouTube, Khaitan in itself has a M&A masterclass series which is there. So a lot of the concepts there may be a little more nuanced, but if you've gotten the base right over here, you can actually give that a try as well, because that clears a lot of practical concepts which are there. I think Tanvi herself has taken a lot of those lectures which are there, and you'll find that.
Actually, an M&A academy, which is more for early stage professionals, and then we also have an M&A masters. Both of those you will find on YouTube, so you can have a look at that.
Thank you.
So it's not a good idea not to come between them and lunch.
Yes. Thanks so much for staying back, and thank you so much for coming. Our pleasure.
Maybe you can change your mind now. I just missed the ceremony now.
Yeah.